All right, good morning. It is July 12th, 2023, and I am happy to announce that this is the inaugural meeting, business meeting of the Colorado Energy and Carbon Management Commission. With that, we will recognize our existence with roll call.
Thank you, Mr. Chair. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray,
Here.
Commissioner Robbins.
Here.
Chair, you have 6 out of 7 commissioners present.
Great. Welcome, everybody. Good to be here and good to see my fellow commissioners. We now will roll into commissioner comments, and if my commissioners will indulge me, I've put together a little bit of a slideshow to announce the ECMC and talk to everybody about what it is that we are now and where we're going. I don't often share screens, so bear with. All right, how am I doing so far? Can y'all see that screen? Okay, as I mentioned, well, my name is Jeff Robbins. I'm chair of the Colorado Energy and Carbon Management Commission. Previously, when I spoke last, I was chair of the Colorado Oil and Gas Conservation Commission. That commission does not exist, and instead we now have the Colorado Energy and Carbon Management Commission. And I've got a little introduction here for everybody. Ms. Larson, if I hit the button, it doesn't seem to want to move. Oh, there we go. Okay. So as I mentioned, we now are known as the ECMC. The transition demonstrates Colorado's commitment to promoting emerging energy technologies in a protective regulatory manner. For 72 years, starting in 1951, this agency was the Colorado Oil and Gas Conservation Commission. We have had some changes, as most folks are aware. In 2019, the legislature and governor provided us with SB 19-181. This changed the mission of the agency from fostering to regulating oil and gas in a manner that is protective of public health, safety, welfare, wildlife, and the environment. And effective actually 11 days ago, July 1, 2023, the Colorado legislature and governor changed the name and mission of the agency to become the Colorado Energy and Carbon Management Commission. And we're going to go by the acronym ECMC from this day forward. This is a quote that I put together to try to explain us, but that we will expand the ECMC's responsibilities by using its talents to usher in regulatory pathways for emerging energy technologies in the areas of carbon capture and sequestration, deep geothermal, and underground natural gas storage. The ongoing experience and expertise of the staff as the former COGCC will continue to guide the organization with some additional staff expertise to accommodate the new emerging areas of emerging energy technologies. And what I want to say here is that I am proud of our agency. I think our agency staff ought to be proud that the Colorado legislature and Colorado's governor determined that these new emerging technologies belonged within the former COGCC. I think that's a testament to the good work that we've done around implementation of SB 19-181, as well as a testament to the deep knowledge and expertise of our scientists and engineers and geologists and all the folks that work with us. I think we really are the right agency to be able to move into some of these new permitting pathways and new emerging technologies. And a big question, what does this mean for oil and gas? Not much. The agency will continue to regulate oil and gas. Our commitment to continue to implement 181 remains solid. Director Murphy and staff are involved in hiring upwards of 29 new FTEs. As everyone knows, it took some time to implement 181 and to implement process around 181. I feel good about where we are and continue to process improve to make the oil and gas regulatory process better and in line with the mandates of 181. Here are the legislation, the legislative pieces that delivered the new areas of authority to ECMC. SB 2316 provided us with the authority around CCS. SB 23-285 provided authority around geothermal and underground natural gas storage. I'm going to note here that we're going to have commissioners take advantage of our full-time capacity, and there will be assignments of commissioners to run kind of the initial pre-decisional facilitation in these new areas as I go through these slides here in just a second. So what carbon capture and sequestration? It involves capturing CO2 from point source emitters, such as industrial facilities, and the transportation of the fluid for a variety of uses or for sequestration in a Class 6 well. Why? Well, it involves underground injection, something ECMC has familiarity with. And next steps are to engage in a rulemaking that is at least as protective as the EPA rules, and then to seek Class 6 primacy from EPA. Currently, EPA is the authority for Class 6 underground carbon capture and sequestration, and Colorado has the authority in ECMC to promote rules and then seek that Class 6 primacy so that we can be the permitting authority. All times are kind of to be determined, but we do believe that we're going to try to shoot for the fourth quarter of 2023, first quarter of 2024, and I will be the Shepherd Commissioner on CCS. Deep geothermal operations. This is the process of using heat in deep subsurface formations to produce energy or for direct heating sources. Colorado has several basins that span large areas with higher than normal temperatures. So deep geothermal is a tremendous opportunity for the state. The why, it's the same. Our experts, our scientists understand the underground attributes of this, and we do believe that we're the right authority for this. We will engage in rulemaking, then seek delegation of authority from PHMSA. Fourth quarter of 2023, first quarter of 2024. This is a very exciting area. And the commissioner that will work initially on facilitating this is Commissioner Ackerman. Then underground natural gas storage. This is the process of temporarily storing natural gas in a subsurface formation to allow for dispatchable gas to generate power when needed. The why, again, it's the same. Our folks understand the geology underground in Colorado. We will engage in rulemaking, then seek delegation. Later, probably 2024, after we accomplish geothermal and CCS, Commissioner Messner will be assigned this topic. We also received direction to undertake a tremendous amount of studies. Here they are, 1, 2, 3, 4, 5, 6, 7 different studies. We're going to have different commissioners and different staff assigned to run as lead on those studies. Those studies will result in many times reports back to the legislature, which may generate additional legislative direction to ECMC. Commissioner assignments. I am in the process of putting together a chart so that we can put this on the website. I don't have it finalized, but as I mentioned, we've got commissioners that are being assigned different aspects of this work. We also have holdover work from SB 181, and then we also have the general day-to-day work around OGDP reviews, CAP reviews, financial assurance reviews, enforcement proceedings, etc. So we're all going to continue to work collectively to work on the new information and areas that we received, as well as some of the other work that's ongoing. Just to kind of recap or to provide some perspective, I will undertake the CCS. I will also undertake the environmental best practices operator. I will help lead the Class 6 study because that involves CCS. And then from previous days, I had assigned the mission change sort of cleanup rulemaking. Commissioner McGowan is going to undertake the work around the CDPHE ozone SIP that came from the governor's March 6th letter, as well as the ozone BMP rulemaking. Commissioner McGowan will also undertake the continuation of the cumulative impacts work. A lot of that is because all of that involves a tremendous amount of work around air and working with our fellow agency CDPHE, and so it did make sense to sort of collectively put all of that within the expertise of one commissioner, and the Commissioner McGowan, who was previously with CDPHE, it made sense there. Commissioner Messner will undertake the underground natural gas storage rulemaking. He also is assigned by the governor as the lead on the produced water consortium, which he can provide some perspective on that at a future commissioner comment. And then he also will run lead on the Raton Basin study that we were supposed to be working on. Commissioner Cross will continue the work that he was leading and facilitating worker certification. He will continue working on the work around permit fees. He is also the lead in terms of making sure that all the studies that we referenced previously are getting taken care of. And then he also will run the hydrogen study. And then Commissioner Ackerman will run lead on the geothermal rulemaking. That's the one that's right out the gate, and we'll be working hard on that front. He also is in charge of the pipeline study, and will continue in all efforts around CPW, including high priority habitat rulemaking, pinch points, and things of that sort. This is just a real quick glimpse at some of the commissioner assignments. We also have other things that we're working on, and I will fill this in with a table so that folks can know who to come to. The changes on assignments are relative to the tremendous amount of additional work for the commission and to allocate work in like areas. The changes are not reflective at all on previous work. We all are working together collectively to advance the cause of now ECMC. I'm extremely proud of the work of all of my fellow commissioners and all of the staff at ECMC and the director, Murphy, and acknowledge the tremendous professionalism and breadth and depth of expertise as we undertake the work of moving forward with the ECMC work. Director Murphy has put together a tremendous staffing plan. This agency is growing to accommodate the new work. She will be creating a unit this fiscal year comprised of a supervisor and key team members who have expertise in 3 fields. Those are the new fields that we just indicated, and then allow those folks to lead the focused policy rulemaking process. Using this team, we'll cross-train and collaborate with the core oil and gas work for the continued benefit and development of all of our employees. I can say to Colorado that our employees are excited about the confidence that the legislature and the governor have put within ECMC, and we are excited on moving forward with these projects. And then working with Megan Castle, our communications manager, we are working to rebrand. That doesn't happen very often within a state agency, but we do need to ensure that COGCC moves seamlessly into the Colorado Energy and Carbon Management Commission. We're creating and implementing a strategic plan to communicate and educate the ECMC mission and expanded regulatory authority to both ourselves internally and externally. This included the bill signing and press releases and stakeholder meetings. Internally, we launched an ECMC toolkit. We're going to have an all hands meeting and talk with all of our folks about this. The website should be redirected. If you go to the old COGCC website, you should now go to the ECMC. There's still some relics because we're still working hard on it, but do give us time to get this right, and we look forward to that. And then, here it is. Here's our website. So with that, I'm going to stop screen share and ask if my fellow commissioners have any comments or otherwise. I just wanted to give a brief introduction to who we are now. Really excited about our new mandate and mission. We'll continue to work proactively to implement 181 on the oil and gas front. And a lot of the tenets around 181, the protective nature of the work that we do, apply crosswise to some of the new work that we're going to be working on. So I'm excited. It's a big lift, obviously, for us and for our staff. But I have a great deal of confidence that we're going to be successful as we move forward. I would also note that in terms of the new authority and moving forward, this isn't kind of an overnight thing. We're not going to, have, bundles of geothermal or CCS within the next, few days. This is a multi-year effort, and we should look at it that way, that we want to be successful in putting down the framework to advance the cause of ECMC and establish protective permitting pathways for all of this new work that we're going to be doing. So with that, I've rambled on for about 10 minutes. Thank you for indulging me. And I would look to my fellow commissioners to see if anyone has additional commissioner comments about ECMC or anything else that's important for the good of the cause. Commissioner Messner.
Thank you, Mr. Chair, and appreciate the update on the work that's being done, and really appreciate all the work that everyone has put into the transition to ECMC and the upcoming work that we'll be undertaking. So very exciting time. I did want to update the commission just a little bit on some of the appointments that occurred for the Colorado Produced Water Consortium, as they have occurred now, and it is timely to let folks know those appointments. To remind folks, the Colorado Produced Water Consortium was created this last legislative session by House Bill 23-1242. The legislation did a number of things, but specifically it developed a requirement that oil and gas operators report specified information on water use in oil and gas operations to the Colorado Energy and Carbon Management Commission, requires the commission to adopt new rules around reuse and recycling of produced water, and it created the Colorado Produced Water Consortium. The Colorado Produced Water Consortium was developed to bring state and federal agencies, research institutions, and institutes of higher education, affected and interested NGOs, local government, affected industries, and others, together to encourage the reuse and recycling of produced water and to address barriers associated with the utilization of this produced water. The Colorado Produced Water Consortium will provide an informed path for the utilization of this water resource inside and potentially outside of the oil field in Colorado. The outcome of this effort will build upon Produced Water Consortium efforts nationally, and will identify and address critical scientific, legislative, and regulatory knowledge gaps needed to develop policies that are protective of public health, welfare, safety, the environment, and wildlife resources in Colorado. The primary goal of the Colorado Produced Water Consortium is to help reduce the consumption of fresh water within oil and gas operations. Responsibilities also include making recommendations around developing an informed path for reuse and recycling of produced water inside and potentially outside of oil and gas operations within the state, measures to address barriers associated with the utilization of produced water, and research to evaluate analytical and toxicological methods employed during produced water treatment and assess tools used to evaluate produced water and its potential for use outside of the oil field. The Produced Water Consortium is housed within the Colorado Department of Natural Resources, who for these efforts will be represented by Aaron Ray, Assistant Director of Energy Innovation for DNR. The governing body of the consortium has been appointed and consists of myself, representing ECMC, Tricia Oath, representing CDPHE, and Tracy Kozloff, representing the Division of Water Resources. The governing body of the consortium was developed to appoint the general body of the consortium, which has now been appointed, and which consists of 4 representatives from state or federal agencies. Those representatives are John Heil from the ECMC, Tricia Feisfer from EPA, Peter McMahon from the United States Geological Survey, and Brandy Honeycutt from CDPHE. 4 representatives from research institutions or institutes of higher education, which consist of Dr. James Rosenblum from the Colorado School of Mines, Dr. Thomas Borge from Colorado State University, Dr. Joseph Ryan from the University of Colorado Boulder, and Dr. Zahi Kath from the Colorado School of Mines. There were 4 representatives appointed from environmental non-governmental organizations, and those consist of Chloel Danforth from the Environmental Defense Fund, Harmony Cummings from Colorado Rising, Barbara Vasquez from Western Colorado Alliance, and Michael Freeman from Earth Justice. There are 4 representatives from the oil and gas industry that are from the 4 different basins within the state that consist of Mark Hefta from Chevron for the DJ Basin, Jeffrey Kirtland from Terra Energy Partners for the Piceance Basin, Mackenzie Smith from Evergreen Natural Resources for the Raton Basin, and Michelina Pollock from the Energy Council for the San Juan Basin. There were 2 representatives appointed for local government. Those consist of Commissioner Emma Pinter from Adams County and Councilman Sean Strode from the city of Rifle. There are 4 representatives that were appointed with experience and expertise in produced water. Those consist of Doug White from NGL Energy Partners, Grant Tupper from Select Energy Services, Eric Anglin from Occidental Petroleum, and Clay Terry from Natural Resource Advisors. In addition to these appointments, the House, Speaker of the House and the Senate President made the following appointments to the consortium. 3 members of a non-governmental organization in the state that works with or advocates for disproportionately impacted communities and communities of color, or who reside in a disproportionately impacted community. Those consist of Kevin Chan from Save the Aurora Reservoir, Nikki Wells from Black Parents United Foundation, and Ember Michelle from the Southern Ute Tribe. There were 3 appointees from a non-governmental organization in the state that works on or advocates for policies related to environmental justice and conservation. And those 3 appointees consist of Irene Andrus from the Sierra Club, Jolie Bronner from the Alliance Center, and finally Jacob Smith from CC4CA. In addition to these appointed members, the consortium will have a full-time director position, which we are currently in the process of hiring. And at a later date, there'll be a second director of research position hired. And so that is my update on the Colorado Produced Water Consortium, and happy to take any questions. I think you're muted, Mr. Chair.
Thank you. Thank you, Commissioner Messner, for the update. Appreciate that. Any questions for Commissioner Messner? Commissioner Ackerman?
No questions. Thanks, Mr. Chair. I just wanted to say thank you. This has been a very large effort on behalf of Commissioner Messner, and just wanted to recognize that. Thank you, Commissioner Messner.
Agreed.
Thank you, Commissioner.
Other commissioner comments this morning? All right, seeing no further comments, we will move to the next item of the ECMC agenda, which is consent agenda. Does any commissioner have questions? Do I have a motion to approve consent?
So moved.
Second.
Motion, Commissioner Cross, second from Commissioner Messner to approve consent. Commissioner McGowan?
Thank you, Mr. Chair. And this is where I always get confused. Is the Western operating enforcement issue on the consent, or is that a different part of the agenda? And I just would like to talk about it a little bit at the point it is appropriate.
Hearings Manager
Mr.
Larson?
Certainly. Thank you, Mr. Chair. Commissioner McGowan, that recommended order is not on consent. It is a recommended order from a hearing officer matter, and you can bring that matter up after consent, and we can entertain it then.
Thank you.
Okay, with that clarification, all those in favor of consent signify by saying aye.
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 Any opposed? Motion carries. Commissioner McGowan, you are recognized to raise the issue that you wanted to raise on the recommended order.
Oh, thank you, Mr. Chair. I don't necessarily have an issue with the recommended order, other than to point out that it's clear that the owner of the ranch is very frustrated with this operator, and to the point where there are articles in the paper about it. And I was wondering if Western Operating was available just to talk a little bit about what they're doing to try to improve relationships with the property owner, and what they're doing as far as making sure that their sites are up to snuff, so to speak, so that we don't keep having these incidents with the property owner.
Ms. Larson?
We can bring representatives into the hearing to address that question.
Are they available, or are they part of our?
They are available. Yes. Well,
Why don't
give
we-
us one moment and we can bring those individuals in.
All right, I see a Mr. Hoffner.
Yeah, good morning, commissioners. I'm actually counsel for K&T, the surface owner. So it sounds like you want to hear from Western first.
And I believe we do have the representative for Western in Kevin. I didn't see the last name in there, but I believe our hearing officer, Mr. Thomas, said that that should be the representative for Western.
Gentleman named Kevin, if you want to unmute. Mr. O'Toole.
There we go. This is Kevin O'Toole. I'm the attorney for Western. Can you hear me?
Yes, we can hear you.
All right, thank you.
Did you hear the question that Commissioner McGowan asked of you?
Yeah, concerning what's going on, we have spent extensive efforts in cleaning up the property and taking care of the property and making sure that the operation is in compliance with the rules. I'm not aware of any citations concerning violations that currently exist. The dispute between the parties has been is now the subject of a lawsuit filed by the surface owner. So, you know, we have to kind of be guarded about what we're going to talk about as far as litigation and what's going on there. And we hope it gets resolved, but we have other counsel handling the lawsuit, but that's been going on for a while, and it's in the courts right now. And that's kind of what where we thought if we couldn't get an agreement in place, it would end up. So that's kind of the status.
Follow up, Commissioner McGowan or Mr. Hoffner, did you have anything you'd like to add?
Yeah, I'd be, unless Commissioner McGowan had a follow-up, I'd be happy to share a few thoughts.
Why don't you go ahead and share your thoughts?
Thanks. You know, from our perspective, our client is a family-run ranch. It's not a huge operation, and they've been living with really quite a number of problems created by Western over, you know, about the past decade. I had a call with a client yesterday in which he reported that the hot wire fence around King Piles number 4, which is the subject of the administrative order on consent, wasn't energized yesterday, continues to be in a state of disrepair. I think he's alerted commission staff to this. The operator also within the past week has created a new road on his property that they weren't authorized to make. They've dumped trash, and they haven't been a responsible operator. And that's why we're in front of you. We understand they've had other enforcement actions in front of you recently as well. And our position is really, you know, the recommended decision needs to do more to bring this operator into compliance. Obviously, the agreement reached between staff and the operator hasn't really had a persuasive effect on the operator to come into compliance because many of the same issues continue to this day. Our client isn't opposed to oil and gas development. He understands, he's the surface owner, but he is opposed to this kind of irresponsible development that's resulted in the death of his livestock, the pollution of his land. He lives there with his family, and this is an operator that's making it difficult, if not impossible, for him to enjoy his ranch. So that's where we're coming from. We have some pretty specific issues with the recommended decision, but I won't get into those unless it would be helpful to the commission.
Thank you, Mr. Hoffner. Commissioner McGowan.
Thank you, Mr. Chair. And I appreciate both parties just coming and kind of giving us an update. And I see how it feels frustrating sometimes how our rules are applied and how they're viewed, Mr. Hoffner. And I think in this instance, our staff applied them appropriately. But I also think, and sorry, Kevin, I don't know your last name because it's not on the.
Kevin O'Toole.
O'Toole.
Mr. O'Toole, sorry. I think it's really important that operators who are on anyone's property, right, are good neighbors. And it doesn't feel like there's good neighbor behavior going on here. And I would encourage our staff to make sure that Western operating sites are not all in a similar kind of condition, and that Western operating kind of look at the way that they're operating things and get up to speed with our rules. And It's really disheartening to see a rancher get to a point where they're going to the paper talking about how their cows died. We don't get to control like how you get reimbursed for dead cattle or whatever, but that should not be happening. That's my 2 cents. And I feel like a parent, but you have to be a good neighbor. And so I hope that we're going to see a change here and some sort of resolution. And I hope that Western Operating is looking at all of their sites for similar issues and making sure that they're getting them into compliance.
You're muted, Mr. Chair.
This double mute thing drives me bananas. The way this is set up is this is set as a recommended order. If the commission takes no action at this point, it becomes an order subject to the potential appeal by the ranch owner. And so if commissioners don't have anything further, I think that at this point, we don't take any further action and we just see what next steps occur. AAG Davenport, did I get that right?
Yes, that's correct, Mr. Chair.
Okay. Commissioner Ackerman?
Thank you, Mr. Chair. I just wanted to ask a quick question procedurally. With us not taking any action, it does become an order, and that in no way precludes other enforcement or other subsequent orders that are associated with this action or peripheral actions on that same ranch, correct? Staff could continue to enforce other violations that they see.
Is that a question for me, Commissioner Ackerman?
Yes, please,
Okay.
Councilor.
Thank you. Yes, that's accurate. This AOC, if the commission takes no action to stay it and the parties to the matter, there's no further appeal or anything like that, does resolve the violations in the AOC. But if there are other violations or if there is corrective actions under the AOC that there are issues with later, then staff certainly has further enforcement actions that are available to it.
Thank you, Councilor.
Okay. Any further discussion on the matter? Okay, seeing no further discussion, we will move on and then we'll see which direction this may percolate next. Okay, with that, I'm going to move to our next matter. That's docket 2201-0009. It is an oil and gas development plan associated with Petro Operating Company. I believe we need to elevate Mr. Pershala and unelevate Mr. O'Toole because we're past his docket. Mr. Pershala, did you have other folks that we need to bring to the panel?
Good morning, Mr. Chair. I see them elevated as panelists. I will be handling the lion's share of this discussion here this morning, but to the extent there's questions, we can elevate the appropriate person.
Great. Go for it.
Great. Well, good morning, Mr. Chair, Commissioners, Director Murphy, and staff. Again, for the record, my name is Joe Pershala with Wellborn, Sullivan, Mecking, Tooley, and I'm here on behalf of Petro Operating. Today, we're continued from the June 28th hearing to resume discussion of a number of proposed conditions of approval that the commissioners had taken under consideration during deliberations. Since the hearing, representatives of Petro met with staff regarding these proposed COAs, and we are prepared to present them to you here today. But before getting into the COAs, I'd like to just first summarize where we left off on June 28th. As found in the director recommendation, staff determined that Petro's application and the LG Everest pad met and satisfied commission rules and the Oil and Gas Conservation Act, such that the application as presented without any of these proposed COAs was approvable. That is, staff had determined that the proposed location, the operational design, including the proposed drilling rig, completions equipment, production equipment, and BMPs were reasonable and necessary to avoid and minimize adverse impacts, including emissions impacts, for the protection of public health, safety, welfare, the environment, and wildlife resources. Nevertheless, commissioners' question expressed concern over whether the proposed operational design and BMPs went far enough to address groundwater and emissions as part of the cumulative impacts to this community nearest the location. I'd like to first reiterate a few important considerations. First is that, as presented by Petro, Fort Lupton is the relevant local government it is conditionally approved the location as originally proposed and designed. And additionally, the proximate local government, Weld County, supported COGDP as presented by Jason Maxey, Weld County's Director and Local Government Designee. There are 4 RBUs within 2,000 feet of this location. These are owners who have for many years lived around oil and gas operations and the sand and gravel operations within which the LG Everest pad is to be located. These owners have expressed no concerns with Petro's proposed operations, and in fact, they provided informed consent on the commission prepared informed consent letter. Operationally, in the near term, sound walls will shield these RBUs from Petro's operations. The quiet frac fleet will be used. Temporary water pipeline will be used for completions, and the legacy tank battery that is located closest to the RBUs will be closed and reclaimed. These are just some of the BMPs that will mitigate impacts to these RBUs. In the long term, oil and gas will be piped away from the location. The location will be connected to line power, all but eliminating emissions from this location. And while produced water will be trucked, these truck trips will be a small fraction of the truck traffic associated with the sand and gravel operations, which is approximately 500 truck trips per week. That's 71 truck trips per day, 7 days a week. As for Petro, it estimates a total of 46 produced water truck trips for the first month of production, and that will decline precipitously to 8 trucks per month after the first year of production, and only 4 trucks per month in the following year. With regard to groundwater, Commissioner Mesner expressed concerns whether groundwater was adequately protected. Petro maintains that the BMPs and commission regulatory requirements are adequate to protect groundwater resources. Per Rule 308B6, as part of the Form 2 process, Petro must provide a casing and cementing plan for the wells to ensure groundwater protection. Rules 421A3 and 60303 require an impervious synthetic or engineered liner under all primary containment vessels, such that the liner be attached to the secondary containment, which is a steel containment ring, as required under the floodplain rule 421B3. The steel containment ring has the capacity to capture 150% of the largest produced water tank on site. Additionally, there will be perimeter tertiary containment around the pad location, and the equipment and produced water tanks will be anchored per Rule 421B2. And per Rule 421A2, Petro can remotely shut in the wells and will empty the produced water tanks should there be a threat of flooding. These regulatory requirements have been determined to be sufficient to protect groundwater even in a floodplain. Moreover, there will be no pits on location and there's no oil storage on site. In addition, the topography of this location and the surrounding sand and gravel operation provides another layer of protection. The location is elevated above all surrounding landscape and is surrounded by excavated areas such that in the event of a flood, those floodwaters would have to first fill the excavated area and exceed the steel containment barriers on the location, which, as we noted, is higher than the surrounding landscape. Petro maintains that these proposed BMPs and commission regulatory requirements already provide reasonable and necessary protections for groundwater, and no further controls are needed. As it respects emissions, I'd like to first address the timing of Petro's operations and then address the updates to the emission calculations. First, Petro's operations are planned to commence in September 2023, which is outside of the peak ozone season. And as for the updated calculations associated with increased drilling time for longer wellbores, cumulative data associated with the additional BMPs, and offset emissions associated with the plugging and abandonment of legacy wells. Then Petro has worked and calculated some figures. These will also be provided in updated Form 2B materials, but I wanted to highlight the items that the commissioners had requested comment on. Pre-production numbers with an increase of 7 days drilling time and commitment to the Tier 4 completion engines. Now this respects to the longer lateral lengths. We calculated a net decrease in NOx and nominal increases to carbon monoxide from 109 tons to 113 tons, and VOCs increased from 52 tons to 53 tons. cumulatively with all of the committed BMPs for pre-production and production emissions, and this includes the Tier 4 engines on the completions, removal of oil tanks, and electrification of the production equipment. Even with the increased drilling time, there will be an overall net reduction of NOx by 27 tons per year, a reduction of carbon monoxide by 111 tons per year, and a reduction in VOCs by 47 tons per year. Lastly, with regard to the decommissioning of legacy wells, there was request for measurements on the overall reduction of emissions. Frankly, there's a nominal reduction in emissions, and the overall measurable benefits will be most reflected in the half-acre of surface that would be reclaimed associated with the tank battery. And then also, all this new production will be located on new equipment on the LG Everest pad, subject to emission controls as per Reg 7. With that, I'd like to turn to the conditions of approval that we discussed at the last hearing, and I'll share my screen here. And can you see my screen?
Yes.
Okay, great. And you see the Petro operating? Just one minute. Yes. Okay, great. On July 5th, 2023, Petro representatives met with staff to discuss the proposed COAs, which I have put up on the screen here. These were the 6 that were proposed during the June 28th hearing. That operator would use Group 3 drilling fluid, operator will utilize a quiet completions fleet, operator will not store any hydrocarbons on site, operator will use line power to electrify the production facilities. And then 5 being operator will utilize Tier 4 drilling and completions engines if available. If a Tier 4 engine is not available prior to drilling, operator will utilize a Tier 2 diesel powered engine. Prior to drilling, operator will email staff stating whether a Tier 4 or Tier 2 engine will be used. If a Tier 2 engine will be used, operator will detail all efforts made to obtain a Tier 4 engine and explain why it was not possible to do so. And then 6, operator will update the emissions data on the Form 2B to reflect the additional BMPs and associated emissions with the extended lateral lengths. The meeting with staff was productive. Petro and staff have agreed to a set of COAs, which are set forth on pages 3 and 4 of the staff supplement to the director's recommendation. I have them here in front of you on the screen. The 6 that are agreed to with staff are that Petro again will use Group 3 drilling fluid, 2, use quiet completions fleet, 3, will not store hydrocarbons on site, and that's the removal of 4 oil tanks as originally proposed, but keeping 2 produced water tanks on location. 4, use line power to electrify the production facilities. 5, Petro commits to using Tier 4 engines for completions. 6, Petro will update the emissions data on the Form 2B. With respect to condition of approval number 5 regarding the Tier 2, Tier 4 engines, Petro has worked with its completions vendor, with whom it's currently contracted to locate and secure a Tier 4 engine completions fleet. With respect to drilling rig, Petro has made reasonable efforts to investigate the availability of a Tier 4 engine drilling rig. It's not currently under contract with the drilling rig vendor. However, it has consulted with 5 drilling rig vendors regarding the availability of a Tier 4 engine drilling rig. Of those 5, only 1 has a Tier 4 engine rig in the DJ Basin, but is under long-term contract to another operator. Petro therefore cannot commit to using a Tier 4 engine drilling rig. As noted in the staff supplement, staff believed that it was more appropriate for Petro to present its diligent efforts to you here today, rather than crafting COA number 5 as putting staff in the place of deciding whether such efforts were acceptable. Petro maintains that it simply cannot acquire a Tier 4 engine drilling rig for these operations, and therefore staff and Petro have agreed to condition approval number 5 as drafted, that it would just be use of Tier 4 completions engines. I think importantly is that these agreed to COAs and BMPs are in addition to the originally proposed BMPs that staff had already determined were reasonable and necessary to minimize and protect public health, safety, welfare, and the environment and wildlife resources. I'd also just make one other note about the Group 3 mud. There was a question about, at least a comment from commissioners, that they were less concerned about the odor, but more concerned with the emissions profile of Group 3 mud. It's our understanding, at least my understanding from the technical folks, that the accepted methodology for calculating cumulative emissions is to use EPA Air Pollutant Standard 42. That standard distinguishes between freshwater and non-freshwater drilling mud. It does not distinguish between Group 3 and Group 2 drilling mud. Thus, the emissions calculations that Petro has already provided based on the Group 2 mud would remain constant regardless of the commitment now to moving to Group 3 drilling fluid, which are both non-freshwater drilling muds. Petro can provide measurable aromatic data showing the differences between the two drilling fluid groups, excuse me, if the commissioners would like to see it. But with that, I would conclude my presentation and request that this commission unanimously approve the LG Everest OGDP with the 6 COAs provided here today. Thank you.
Okay, with the present finalization of the presentation, we turn this back to commissioners if folks have questions. Commissioner Messner.
Thank you, Mr. Chair. So, Mr. Prishala, you rattled off a bunch of different emissions reductions numbers, but it was not clear to me where these numbers were coming from or what specific things were creating reductions and what that was a reduction from. And so I guess I'd ask for a little more information on that, particularly when you're indicating that there's 27 tons per year NOx reductions. But what are those NOx reductions from? Is it from a reduction from your original proposal? Is it a reduction from something else? It's not clear to me.
Yeah, it's my understanding that it is a reduction from our original proposal. That's including the Tier 4 engines, as I mentioned, removing the oil tanks from the site. And then we have the electrification of the production commitment. That's the commitment as well. But I can't answer in more detail where those numbers are specific to, but I understand that it's cumulative as to all of the best management practices that are being employed. My understanding is that it's not calculated on these specifics, but let me turn that to Jessica Donahue and Alex Corey if they may be able to give more color on that.
And Ms. Donahue, just noting for the record, to create a proper record, you've been sworn in a couple of weeks ago. You remain sworn in. So with that, please go ahead and testify.
Of course. Good morning, commissioners. For the record, my name is Jessica Donahue. I am with Ardor Environmental, representing Petro operating today. As Mr. Prishala conveyed to you, with the intent of answering the commissioner's questions from June 28th, we went through and looked at all the emissions that had been submitted on the Form 2B, and we recalculated based on the BMPs that Petro is now committing to in front of you, such as electrifying the production equipment, removing the oil tanks from the LG Everest location that had been, while they had not been intended to be a daily usage, they had still been included in emissions calculations for the potential of having hydrocarbons on the location. So by removing those oil tanks, by the electrification and some of the other modifications that we've made to the site, that's where we got the overall cumulative net decrease in the NOx and the CO and the VOCs.
So again, to be clear, you're indicating that your reductions are from the original proposal to the current proposal. So the reductions that have been indicated are reductions from your original BMPs to the current BMPs.
Yes, the reductions are comparing the originally submitted Form 2B to what we've calculated now.
And you're providing an updated 2B to quantify these specific reductions that you're proposing?
Yes, we will be submitting it to staff.
Okay, thank you.
Commissioner Ackerman.
Thank you, Mr. Chair. And admittedly, this question requires a little bit of speculation, Mr. Priscilla or Ms. Donahue, whichever is most appropriate. And I do appreciate the efforts to look for available Tier 4 drilling engines, as well as the other efforts that have been made since our last hearing. My question would be, I think from what you described, you reached out to 5 different vendors. One has a Tier 4 in the area, but they cannot commit because they are already committed to another operator. My question is, would more advanced planning with Tier 4 engines in mind have put you in a position where you could have been able to acquire a Tier 4 engine, or maybe even electric highline power, rather than doing it, between meetings here? And were those efforts made originally?
Mr.
I will
Pacheco?
take a shot at answering this, but I think I'm going to have to defer to the expertise of either Ms. Donahue or Mr. Corey. My understanding with respect to highline power, I think the commissioners are very aware of the difficulties of connecting to highline power for a number of reasons, based on one, just the local providers even being able to commit to something like that. The fact that it is a tremendous amount of power, especially for drilling on the front end, that drops off precipitously. And when you don't have the economies of scale associated with a larger development plan, it really just does not make economic sense for either the operator or the power provider to make the necessary upgrades for highline power associated with a single location. With regard to planning and the availability, it's my understanding of availability of Tier 4 engines. It's my understanding that there just simply no Tier 4. They're incredibly limited Tier 4 engine drilling rigs. Whether that could be planned in the long term, I would have to defer to Mr. Corey on whether that's or Ms. Donahue, whether that's even possible. But as far as I understand it, it's just a very scarce resource and would be very difficult.
This is Alex Corey with Petro Operating. I just want to jump in as well. Yeah, we looked for Tier 4 engines prior to while preparing this OGDP, but they're just simply not really available in Colorado. We even looked at potentially bringing something up from Texas or from Wyoming, and even those were really not feasible for the time frame of the operations we're looking at. So,
Commissioner McGowan.
Thank you, Mr. Chair. And thank you for the additional information and the additional commitments to the BMPs. I think maybe I need to have some more discussions about Group 3 drilling mud, because I feel like I'm hearing conflicting and getting conflicting information from operators. So let's put that aside. I'm glad that you're committing to it. Lower odor, from my understanding, it's the better emissions profile. I'm wondering if you all have thought about or are able to think about if you have to use a Tier 2 engine, using some sort of dual fuel or battery assist to try to figure out how to lower emissions from that activity for drilling.
I'm going to have to defer to Ms. Donahue or Mr. Corey on the availability of those technologies.
this is Alex Corey again. Thank you for your question. We are currently still discussing with different rig vendors what they have for Tier 2 engine plus, if you'd say, but that's going to be very dependent on what rigs are available for the time frame. I know some have hybrid fuel systems, some have battery pack systems, but it's hit or miss whether they're available. And that's why we're not willing to commit to necessarily anything beyond Tier 2 for that, even if it's available. It's just very difficult to acquire that in any certain time frame. On the other side, frac, we were able to confirm we would get Tier 4 engines, so we were willing to make the commitment that we can, in fact, get Tier 4 engines for that. So,
Further questions for the panel? Okay, thank you, panel, for the continued presentation and for answering questions from commissioners. Commissioners, at this point, I believe we pull this back to ourselves for deliberations. Commissioner Ackerman.
Thanks, Mr. Chair. And for those who might be listening, we had, relatively significant discussion about this OGDP already, and are just addressing some points from the previous hearing, and certainly had some deliberations associated with that. But with regard to the deliberations today, my only comment is that I guess twofold. First off, I believe this OGDP does fit within our regulations, is an approvable OGDP. And I appreciate the extra steps that this operator has taken since our last meeting to try and bring down emissions. It does demonstrate that with a little thought and a little dedication, we can continue to bring down emissions. I also recognize that those are steps that are arguably over and above what the baseline of our regulations is, and recognize this operator's efforts to do what they can to continue to reduce emissions. I would encourage all operators, particularly those who are operating in the non-attainment area, and again, once again, understanding that our regulations set the baseline, but to be able to bring packages forward that proactively reduce emissions in every aspect possible, particularly in that area. So I think that's all I've got on deliberative comments. Thanks, Mr. Chair.
Thanks, Commissioner Ackerman. Commissioner Messner.
Thank you, Mr. Chair. And thanks for going first, Commissioner Ackerman. I think that there's, as I indicated before, I think that there's some very good things about this, this proposal. I think I think it's an existing location. It's got informed consent. It's got remote shut-in. It's got electrification of production equipment. It's, already, a significantly impacted surface location located within a gravel pit. I think there's a lot of solid BMPs around noise and odor and lighting and accessory emission reductions during ozone days. And I do think that the additional BMPs that are being proposed, improve the profile of this particular application. I don't think that they're actually over and above. I think that they are necessary and reasonable for this particular location with the profile of this particular location. They've removed tanks now. They've committed to Tier 4 engines for completions, which is significant. They've committed to the Group 3 drilling mud. I'll go back again to the EnviroScreen analysis, and that I think that's a very strong tool for us to look at as far as determining what's reasonable and necessary as far as environmental best management practices associated with proposed development. And the EnviroScreen score in particular areas was really, really high. And so I'll continue to look at that in determining what BMPs are appropriate, even in the instance of informed consent, to ensure that the proposals that are coming forward, meet the basic intent of our rules, which can be found in 301A. Where I get stuck is that I do actually, as I analyze this against our existing rules with the modifications that are proposed, I think that this application potentially meets the current state of our rules. But at the same time, I think that there's a challenge here, because while our rules, are what they are at this point, We've also received a directive from the governor around the reduction of emissions associated with oil and gas activities. And that letter is specific in what it is requesting us to do, but I think the context and the intent of the letter is important to understand, and how decisions that we make today and proposals that operators are making today are going to inform the ultimate rules and rulemakings that will occur in a very short amount of time here, particularly from this commissioner's standpoint, on what those rules are going to contain and what the requirements are going to be in order to meet these directives that have been given to us by the governor. You know, to read from the letter, the governor states, "I am focused on common sense efforts to cut pollution and continue to grow our economy while making our air cleaner and our people healthier. It is also important to continue this work in partnership with the legislature and to faithfully and successfully implement past oil and gas reforms, such as the landmark SB 19-181. Despite passing meaningful and effective legislation to reduce emissions from oil and gas operations, this sector still has significant impact on our state's air quality and greenhouse gas emissions. Put simply, just as we need to do more in transportation and other sectors, we need to do more to reduce emissions from oil and gas operations in Colorado." For 2023, oil and gas is projected to be the largest contributor of ozone precursor emissions in the non-attainment area on a per ton basis, daily per ton basis. And it is estimated that oil and gas extraction activities are responsible for almost half of total ozone in the Denver metro area. These emissions have not yet been subject to actions that require steady, measurable emissions reductions on a schedule commensurate with meeting our air quality challenges. And today, that will change. The oil and gas industry in our state should take a more ambitious approach towards doing their part to address Colorado's ozone problems. Recent technology innovations and operational changes, in many cases driven by current state policy, demonstrate that Colorado's oil and gas industry leads the nation in clean air operations. However, in many cases, the solutions used today were not foreseeable only a few years ago. Like other sectors of the economy, the best strategy to achieve a goal is to set clear, measurable targets and take robust administrative action to facilitate meeting those targets. As has been true for the power sector, it can be true for oil and gas as well. The letter goes on to talk about the ambitious rulemakings that should be undertaken to reduce pollution from the oil and gas sector, and the first comprehensive nitrogen oxide reduction program in the oil and gas industry. And so I read that to indicate that in an industry that continues to tout its technological innovation and its ability to reduce emissions, to continue to see proposals that utilize what at this stage in a non-attainment area based on the expectations from the governor and the state citizens of the state of Colorado, antiquated technology is going to be problematic. And while I may or may not be able to apply our existing rules today to that, I think that the actions taken by operators today will inform the necessary rulemakings that need to occur in the very near future. And so I'm disappointed to continue to see operators proposing tier 2 diesel engines in drilling rigs. I'm disappointed to continue to hear that there's supply chain issues or operational challenges associated with accessing other technologies that could mitigate the emissions associated with tier 2 diesel engines. I've not heard this operator propose anything besides, the fact that they've reached out to 5 operators and it seems problematic to be able to access a tier 4 diesel engine. I'm not sure it's the purview of this commission to take into consideration supply chain challenges or construction timelines in our decision making on whether or not the appropriate technology or equipment is available for operators to be able to conduct their drilling operations. And so I struggle with this, and I continue to struggle with this. And I think at this stage, I also would hope to see more robust CDPHE consultations associated with OGDP applications that we have. This directive was given to us a few months ago. We had certain consultation protocols that CDPHE provided to us, prior to this directive, but this directive clearly indicates that we need to better coordinate with CDPHE in our consultation on how we address cumulative impacts, how we address emissions, and how we'll ultimately address these NOx reductions as part of the directive. And so I am hoping to see stronger CDPHE consultations, on these OGDPs, and more of them, including the utilization of the EnviroScreen tour tool in these. And so sorry to be long-winded there, but I think I wanted to express to you the difficulty I have in deliberating on these particular things in light of a new directive that we've received from the governor, and understanding that decisions that we make today will inform future rulemakings, and the quality of proposals that are coming from operators can either hurt or hinder, I think, future operators' proposals or future operations from other operators within the state, because collectively we're looking at this cumulatively together on how the oil and gas sector can help or hurt efforts towards reducing emissions. So that's my soapbox today. Chairman, you're muted.
Thank you, Commissioner Messner, for the words. I'd like to follow up a bit because I take a little bit of a different approach to the work we do relative to the review of OGDPs versus the work that we are challenged to do from the governor's March 16th letter, because I think those two things are different. And I want to try to help with the struggle because I don't think there really ought to be that much of a struggle here. I look at this application and I look at the rules that we have in place, and I'm in agreement with Commissioner Ackerman that this meets the rules that we have in place at this point in time. I am appreciative of the operator's additional efforts to reduce emissions. And I'm appreciative that that might inform us as we undertake a rulemaking as directed by the governor. The governor's letter had 3 directives to us and CDPHE collectively. To CDPHE, they are to undertake a SIP rulemaking that addresses the NOx reduction goals that the governor met, the 30% by 2025, I believe, and 50% by 2030, I believe, are the goals. And Commissioner McGowan, I know, is doing a good job of monitoring that for us. Those goals are not within our rules today. And I think that's an important understanding. The governor's point was to set goals for industry and then to allow the regulated agencies and industry and all appropriate stakeholders to figure out how to achieve those goals. But those goals are not, there's not a rule that we can go point to that requires the meeting of that goal right now. That is something that we in CDPHE will be working on. Second, the governor told us that we are to undertake a rulemaking to create best management practices to reduce ozone in the non-attainment area. That is not something we've done yet. That is a rulemaking that we are directed to undertake, and we will do that in due time. I believe that the way we set it up is we're going to listen to CDPHE, figure out how they're doing the ozone non-attainment NOx reductions, and then with that, use that to inform our process. And I know Commissioner McGowan will move forward with that in due course. The third thing that we were to undertake is to create a operator best management practices program. And that was to, and that's something that I'm going to work on, and I'm excited to work on it. And that's to work with operators to identify some of these best practices and establish regulatory pathways when operators are going to be using these best practices to allow for the incentive to use these best practices. That too is not something that's in our rules right now. That's something that we are going to work on. So the 3 directives we've got, I agree with the concept that we all need to be working toward emission reduction and non-attainment. And I agree with the concept that we ought to have operators coming in with the best practices. But OGDPs are to be reviewed based upon the rules we have in place now. And I believe that this operator has met those rules. And I believe that up and until we undertake the ozone best management practices rulemaking, when we alter our rules, we need to be cognizant of the rules that we have in place now, and we need to judge OGDPs accordingly. And so I don't have as much of a struggle, because there's a difference between what we're doing today and the rules we have in place now and the directive that we are told to go to probably this fall and the work that we're going to undertake. And it's always going to be getting better at the work that we're doing and providing that through rulemaking. So those are my thoughts about where we stand today, where we're going in the future, and the sequential work that's going to happen, and how we need to be looking at OGDPs, at least from this commissioner's perspective, given the rules that we have in place right now. And I also sort of, well, I'll stop there. Commissioner Cross, I know that you had raised your hand. I'll let you provide some deliberative thoughts as well.
Thank you, Mr. Chair, and I want to thank the commissioners for their prior comments as well, because I think a lot of what was said by all 3 of you covered what I wanted to say. And I want to start off saying I agree with Commissioner Messner that based on, excuse me, based on what the governor has instructed us to move forward to and what we want to do, I think it's incumbent on operators to take that into account moving forward, that we do have these lofty but achievable goals, and an industry that has taken many steps already to improve through technology, through different best management practices, to improve on emissions that occur from oil and gas exploration and development. And as we get these lofty goals, I do think it is important for operators to come up with the best plan that they can. That said, I also don't think that it's something that we can, and Commissioner Messner, I believe you said this during our last hearing as well, this is not something that we can be prescriptive about. And so I think that's the one place that I differ in what your statements include, is that when we talk about, I don't think we as a commission should be taking into account supply chain issues, et cetera. We still have to look at the proposal that's provided to us at this time. And as Chair Robbins said, we have to look at, and I think for me, the additional time taken by the applicant here was important to put forward additional commitments that they can undertake and likely should have undertaken when first presenting this application. That said, I don't know that it creates any kind of detriment to say we have undergone these efforts to, as Commissioner Ackerman asked about, prior to this hearing, what steps did you take to look into Tier 4 engines, to look at other options? And then again, after the first meeting for this application, again, what vendors did you talk to? What steps have you undertaken to try and get additional technology, better drilling engines, et cetera? And when we do look at that, we have to look at what's provided to us. And given that in my opinion, I think the operator here has taken the necessary steps to say, we've looked at what's available under what we're trying to do, under the application of what we're trying to do. We've taken the steps that we can with respect to removing tanks, with respect to making sure we have shut-in capabilities with respect to using an existing location that's already got disturbance to it, and taking those steps to have BMPs to say, this is an appropriate application for approval. And so I will agree that I think this is an approvable application. I will be a yes vote on it, but I do agree with what Commissioner Messner is indicating here, and that's, as an industry, operators need to be moving forward with the best technology, the best applications they can, because we know that, as Chair Robbins indicated, there will be rulemakings coming. CDPHE is going to be requiring reductions in emissions. We're going to be requiring reductions in emissions. And as we move forward, it's in all operators' best interest to put forward the best application possible. I don't think it's a matter of saying this meets the bare minimum of the rules. I think it's a matter of saying, yes, if something does meet our rules, it can be approvable. But I think in order to meet our rules, to avoid, minimize, and mitigate adverse impacts, you need to take the best steps that you can. And I do think that that was done here.
Commissioner McGowan?
Thank you, Mr. Chair, and thank you for the wise words of my fellow commissioners. It's always sometimes easiest to go last. I think I might have a little bit of a different perspective in that I think my struggle with some of our recent proposals has been with respect for private property rights and people's ability to sign informed consent and their desire to do so, but still make sure that we are not forgetting the other important aspects of our rules, which are the hierarchy of avoid, minimize, mitigate. And then the other large, most important piece, which is it still protective of public health, safety, welfare, environment, wildlife resources? And in this case, I did not feel that the operator submitted their application in a way that still looked at protectiveness and avoid, minimize, mitigate. I think what they've brought to the table is much better. I wish this is what would have been proposed in the first place. Just because people signed informed consent does not mean that this commission is still not responsible for making sure that emissions are minimized to protect public health, and that we're doing everything we can, especially when we're within 2,000 feet, to honor what we've said as a commission is we're going to be protective. We're going to avoid, minimize, mitigate. I think this goes a lot further. I think it's better. I still wish the tier 2 engines for drilling had a commitment to some sort of minimization and an attempt to reduce emissions, because I think the emissions from these large engines have ozone precursor emissions. Some of them have CO2, some of them have other emissions that do affect people's public health. NOx is a public health set criteria. There's a reason that we have a state implementation plan, and there's a reason that EPA sets the criteria in parts per billion, because it does affect people's health. It affects how they breathe. It can affect getting headaches. It's very impactful for people who have pre-existing health conditions. And I think that it's our job to make sure we're trying to protect people that are especially within 2,000 feet, in addition to what's happening in the non-attainment area. So I agree. I think this proposal is approvable, but I think that we had to pull some teeth to get it to the point of approvable. I think as it was submitted, I did not feel it was protective of public health. I think in addition, there is a cumulative impact here for what's happening already to the people who live near this gravel pit. And we can't forget that what we're doing is additive to someone, and we need to pay attention to what those additive impacts are and figure out how do we minimize our impact as we're putting forth these proposals. So thanks for the time.
Thank you, Commissioner McGowan. Thank you, Commissioner Cross, and thanks to all the commissioners for the comments. Commissioner Messner?
Thank you, Mr. Chair, and agree with Commissioner McGowan. Thank you for everyone's wise words. I do want to make sure that I'm not mischaracterized, because the struggle for me is that the application may actually meet the rules. But I don't think it meets the intent of what the industry has indicated it would be able to accomplish as per the governor's directive. I acknowledge that, and acknowledged it in my initial statement, that the governor's director requires rulemakings as its primary focus in those three things, and that those rulemakings haven't been undertaken. And so therefore, the actions by the applicants up until that point inform those rulemakings. And that's what I'm indicating in my comment, is that by continuing to propose certain technologies or characteristics and applications, I think that from this commissioner's standpoint pushes me towards certain requirements in future rulemakings in order to be able to meet the governor's directives. And these applications, these OGDP reviews, are just information that I utilize in that. But I do apply the rules to the applications. And so that's where I was indicating the struggle was between the fact that this may actually meet the rules, but I'm not sure it was the best effort by industry to continue to innovate and push to create the cleanest molecules of oil and gas in the world, as industry continues to indicate that it is able to do and will continue to do. But I think some applications that I see don't show that. And so that's my struggle. That's what will continue to be my struggle. And I think Commissioner McGowan hit a really important point, that when we talk about NOx emissions reductions, when we talk about other emissions reductions, it's not from just a global climate change emissions perspective, but it's from a more direct public health perspective in looking at cumulatively how individuals in certain areas are impacted by oil and gas activities and emissions profiles of those. And so I'm expressing to you that these are difficult decisions for me to make. In anything, I will apply the rules as is my job. But in these instances, I struggle with that. And I'm just going to give you just a couple of numbers here that I went through as I'm trying to decide whether or not this meets the rules or not. But we had a previous application by Civitas that provided a lot of interesting data for this commissioner. They had 9 wells, and they indicated that if they utilized tier 2 diesel engines, that it would produce 22 tons of NOx, or 2.4 tons per well. If they utilized tier 4 engines, it would actually overall produce 8 tons of NOx for those 9 wells, or 0.9 tons per well. If they utilized a tier 2 engine with natural gas and battery backup, it would produce overall 12 tons of NOx, or 1.3 tons per well. So applying those numbers to this particular application, which is a 12-well application, and I know that there's going to be variances and differences amongst these, but this generally is what I'm looking at, is that same tier 2 engine that's being proposed, utilizing those numbers of 2.4 tons per well, is 28.8 tons of NOx, right? So they may have had a reduction in 27 tons of NOx from these other BMPs, but they're still producing 28.8 tons of NOx utilizing the tier 2 engine for drilling. If they were to utilize a tier 4 engine at 0.9 tons per NOx, they would only produce 10.8 tons of NOx overall for this. And so it would have had a net reduction in NOx emissions if you included their existing reductions on the BMPs that they've proposed to this point. And if they would have utilized some other tier 2 technology combo, like natural gas with battery backup, it could have reduced the NOx to 15.6 tons per overall at 1.3 tons per well. And so I say this to say that the technology is available, the technology is out there, it's possible to do these things. We've seen other operators do these things, and I hope that we can continue to see that level of work in these applications, because these are not small emissions reductions. You know, by utilizing a Tier 4 engines, it's almost a 60% reduction in NOx emissions according to these calculations. And so that's to me a big deal as I start to look at these things as per a new lens from the governor's directive, understanding that there is an intent of the directive and then there's the actual rulemakings that will occur in the relatively near future. So that's just a little more.
Thank you, Commissioner Messner. Are there further deliberative comments at this point? Seeing none, I would make a motion to approve this application with the conditions of approval as articulated by the applicant here today.
Second.
Motion and a second. AG Mercer, do you want to make sure that we're motioning correctly here?
Thank you, Mr. Chair. I think the record is sufficiently clear in this case because we had them listed out on the slide today, and you referenced the ones committed to by the operator today. So I think we are good.
Okay, thank you. And thank you for attending to us and getting our back as we move forward in these sorts of things. We have a motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries unanimously. Okay, thank you, folks. Good work here. Thank you to the panel. Thank you to staff for working with us on this application. We've been going at it for an hour and a half. Why don't we take a 15-minute break and return at 10:36 or 10:46, excuse me. Up our next docket. The docket is 221200360. It's a Bayswater exploration and production proposed OGDP. We do not have public comment for this. Ms. Ryan, I see that you are ready and available. I do believe that we wanted to call upon the oil and gas location assessment analyst for a brief presentation before we go into your presentation and or Mr. Maxey's. Is that okay with you?
That's great. Thank you.
Ms. Housey.
Yes, thank you. Good morning, commissioners and members of the public. My name is Melissa Housey, and I am the lead oil and gas location assessment specialist on the Bayswater Onyx OGDP. I'd like to take a moment of your time to clarify for the record 2 minor corrections to the director's recommendation as requested by the applicant. First, although it is indicated that CDPHE conducted a formal consultation in the director's recommendation, a formal consultation did not occur for the Onyx OGDP. Instead, Bayswater discussed similar BMPs that Bayswater could commit to with CDPHE during formal consultation for a previous OGDP. The BMPs were provided with the Form 2A as an attachment. The following interactions took place between COGCC and CDPHE regarding the proposed Onyx OGDP. COGCC staff alerted the CDPHE liaison about the proposed location and provided a description of the setting to allow CDPHE to determine if a formal consultation was necessary. Although not considered to be a formal consultation, staff met with CDPHE on June 21st, 2023 to discuss the OGDP and the BMPs provided by the operator from the previous OGDP consultation. The second is on page 3 of the director's recommendation. It states that oil and produced water from the Onyx location will be stored in tanks on the Leffler 26A pad and then trucked off location. The correct statement should be oil and produced water from the Onyx location will be stored in tanks on the Leffler 26A pad, and then oil is sold via pipeline and produced water is trucked off location. Thank you for your time.
Thank you, Ms. Housey. Do commissioners have any questions with regard to those clarifications? All right, seeing none, I think the normal order of play would be for me to recognize Mr. Maxey at this point. Good morning.
Good morning, Chair Robbins, and good morning, Commissioners. Again, Jason Maxey with the Weld County Oil and Gas Energy Department, and as always, appreciate being able to be in front of you for just a brief few minutes to discuss the Weld County process and our review of the permit that is in front of you all. Do appreciate the comments from Ms. Housey just there, especially the one about oil takeaway, because that does align with Weld County's final order that was issued by the hearing officer. So thank you again for the few minutes just in regard to the Bayswater Onyx Oil and Gas Development Plan. As is included in your record, the 2A comments were submitted by Weld County on April 25th of 2023 and are included in the director's recommendation. We did our normal pre-application process for this location on April 6th of 2022, so a little over a year ago. At that meeting, there were several alternative sites discussed with the attendees and with the applicant. Attendees did include Bayswater staff, along with their consultants, Ascent Geomatics, representatives from the town of Eaton, Weld County staff, and the COGCC, now ECMC staff. That's going to take me a while to get used to that, by the way. So if I slip up, apologies. We have assigned case number 1041 WOGLA 22-0017 to this location. We received the application on October 18th of 2022. Through our application process, we did not receive any public comments or applications to participate in our hearing process for this location. I do want to mention Bayswater did provide evidence of signed informed consent from the 3 building unit owners within the 1041 WOGLA zone. So we do appreciate that being included in our process, even though that's not necessarily a requirement. That's a requirement of you all. We do appreciate that because it does show interaction with the public, and them providing that evidence is very helpful, not only for staff, but also for our hearing officer when reviewing cases such as this and when there are homeowners within that 2,000-foot buffer zone. We held our hearing earlier this year on February 2nd of 2023, and it was approved by the Weld County hearing officer. He issued a final order, which has been recorded with our clerk and recorder, and as per our process was noticed in the Greeley Tribune on February 17th of 2023. We do believe this location best consolidates impacts by being immediately adjacent to existing oil and gas development. And I know the applicant will go into further detail on that, but some of those impacts that we believe are addressed by being immediately adjacent are items such as traffic and access. They are close to infrastructure for pipeline takeaway, as well as electrification for production equipment. Due to those considerations and due to the fact that Weld County has already heard this case and the hearing officer has issued a final order, Weld County does support approval of this permit. Thank you very much for the few minutes of your time, and be happy to answer any questions if there are any.
Great. Thank you, Mr. Maxey. We appreciate you presenting to us on applications in which your department is the relevant local government. As we've indicated previously, that's an important component to the work we do here. Does anyone have questions of Mr. Maxey? Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Maxey, for, as always, for being here today. I'm wondering if I think when I read the background that Weld County asked for another alternate location to be considered. And I'm wondering if you could talk a little bit about why the county asked for an additional site to be considered, what the thoughts were there.
Thank you, Commissioner McGowan. I appreciate that question. Is there any way that you could give me a little bit more detail about, was it a certain location that you're asking about in particular, about why we asked for that alternate location to be discussed, or just in general?
Well, if I'm remembering my numbers correctly, there were 11 alternative locations considered and Weld County asked for a 12th. And that just kind of made me think that maybe Weld County thought that there was a more appropriate location.
Okay, thank you. I was reading back through the hearing officer's order this morning before this meeting, and I did see the number 11 in there as far as there was 11 alternates. I'm not locating the 12th one. I will just say in general, when we're looking at alternates from a land use perspective, number one, I think that our process mirrors what I hear you and other commissioners talk about as far as avoidance first. We look for those open areas to where there could be no conflicts, whether that conflict be a homeowner, whether that conflict be prime or actively irrigated cropland or wildlife considerations. So I see Ms. Walsh with Bayswater does have her hand raised. She can probably speak to the 12th location in greater detail than I can, but just in general, especially since our pre-app was over a year ago and the hearing was earlier this year, in general, we look for those areas that are less points of conflict, similar to how you all look at them. And I think our process really helps facilitate those types of discussions. And when we ask our questions for the pre-app, we definitely come with an idea of areas that we want to ask the operator about, did they consider or not? And if the answer is they did not consider them, why did they not consider those areas? So sometimes we come prepared with a handful of locations to ask, and then through the course of discussion and answers between the operator and us, or even from your staff or from whoever else the attendees are. In this case, the town of Eaton was an attendee as well. They can uncover other areas that we might look to ask about consideration. I'll let Ms. Walsh go into greater detail when it's her turn to come up for the alternate siting, but just answering in general terms, not too specific for you, so I apologize for that. But through conversation, we could come up with other alternates that we want them to address that might not be fully prepared in our notes leading up to the meeting.
Okay, thank you, Commissioner McGowan. Did you have anything further? I'm sorry.
Thank you, Mr. Chair. And then if Ms. Walsh wants to jump in, if she has a better recollection of how that conversation took place, that would be helpful. I'm wondering, can you remind me, are the local rules for setbacks similar to COGCC's? I think yours are a little different.
Yes, thank you, Commissioner. They are a little bit different. So while on the surface they might appear very similar, such as a 500-foot setback, again, we might measure just a little bit differently. While our buffer zone, our 1041 WOGLA zone is 2,000 feet and yours is also 2,000 feet, we measure a little bit differently. So in the case of the 2,000-foot buffer, you all measure from the working pad surface, and we measure from our definition of what the oil and gas location is. I have not seen one example to where the oil and gas location is smaller than the working pad surface. 100% of the time over the years that we've been doing this together, and this relationship and this coordination between our two groups, the working pad surface is always within the Weld County definition of the oil and gas location. Therefore, our measurement of 2,000 feet is more conservative or more strict than what the ECMC's definition and measurement is.
Thank you. So in this case, there's an existing location 600 and some feet away from where this additional location will be. From a WOGLA perspective, from Weld County's perspective, how do you look at kind of a cumulative impact and an existing source, a new source being put right next to an existing source within that 2,000-foot buffer?
Meaning, if I can clarify, meaning that do we take into account the existing piece of the puzzle, and do we measure from that or simply from the new proposal?
Well, so, I mean, I think I don't know if it's a complicating factor. One factor here in this proposal is that there is an existing location already quite close to one RBU. And this proposed location will be right next to this existing location that is, I'm trying to remember the exact number, let's say 660 feet from an RBU.
Mhm.
And I'm wondering what Weld County's perspective would be when they see a proposal like that, and what additional BMPs you might be asking for when you see this kind of situation, and or if you did consider additional BMPs as part of your review process.
Gotcha. Okay, thank you for that clarification. So when we're looking at surface considerations, we look at, obviously, same as you, we look at a variety of factors. The fact that there is an existing oil and gas location basically in between this proposal and the closest building unit, which is that distance you mentioned, about 600 and some odd feet. We look at that almost as a little bit of a buffer, to be honest with you. We look at it the same way as we would look at like a railroad tracks or a major highway that would split the distance between a new location and a home. There are factors that come into play with those land use type of items as well. Or there could be, another land use permit like a solar energy facility or a dairy that's between the closest home and this proposal. Those land use factors are in essence a little bit of a buffer in and of themselves, so to speak. So in this case here, even though the closest home, which was one of the informed consent signers that we received confirmation from Bayswater on, they already have that oil and gas that's close to them. They're used to that. So this one is further away from those that closest homeowner and from the others as well. And we look at those surface considerations about how can we mitigate any additional impacts on the surface, such as the ones I mentioned. Traffic would be a big one. They're going to pipe oil off of here, so there is no additional truck traffic that would be a consideration that Weld County would be concerned about. They're not proposing an additional access point. They're going to use the existing access point, which increases the safety of the location because it's less access onto the county roads. So while we don't necessarily look at it from an expanded view, saying the existing location is there and wrapping that existing location into this permit, because that's not the proposal, we do try to work with the operator to say, what can you do since there is existing development here to make sure that this new one is no more intrusive or no more burdensome on the homeowners or the community than what they're already used to. And in the case of this example here, Bayswater has committed to lighting and noise and odor standards that make us believe that it is compatible due to the fact that an existing location is already there, and this would not be any more intrusive than what the close homeowners are already used to. We also, I do want to mention, we also take a look, and we also do believe that when a location such as this can be adjacent to existing development, that is much better, in our opinion, than having a new development somewhere else that might impact other homeowners that aren't already used to living next to this type of development. So we look at this as a consolidation in and of itself because it's right next to something that people in the community are already used to.
That's helpful. Thank you.
You're welcome.
Further questions for Mr. Maxey? Okay. Thank you, Mr. Maxey. We appreciate you being here. Thanks for answering the questions. If something comes up, I know how to reach you, but thanks again for the presentation this morning.
Thank you.
Okay. Ms. Ryan, why don't we take care of procedural issues first and have your witnesses sworn in?
Absolutely. I believe a few appear to have dropped off actually at one point. Oh wait, maybe everyone's up. Let's see. I believe we still need. I'm not seeing Mr. Kaminsky or Mr. Carney.
Give us one moment and we'll bring them in.
Oh, actually, I see Mr. Carney now. Oh,
Yeah, looks like we got both.
okay, wonderful. The names went away. Yes, please swear in. Thank you.
Ms. Mercer?
Thank you, Mr. Chair. So for all of the witnesses, I'll go one at a time and just ask you to raise your right hand, state your name, and say that you swear to tell the truth. I will start with Mr. Carney.
Robert Carney,
I swear to tell the truth.
Thank you. Mr. Kaminsky?
Ryan Kaminsky, I swear to tell the truth.
Thank you. Mr. Rogers? Oh, if you could unmute yourself, please.
Brad Rogers, I swear to tell the truth.
Thank you. Ms. Walsh?
Lauren Walsh, I swear to tell the truth.
Thank you. Ms. Feldman?
Tell the truth.
I'm sorry, we couldn't hear your audio at first. If you could just do that one more time.
Ann Feldman, I swear to tell the truth.
Thank you very much. Mr. Overman?
Jeff Overman, I swear to tell the truth.
Thank you. Is it Mr. Struna?
Yes, Steve Struna, I swear to tell the truth.
Thank you. And is Mr. Hammond a witness as well?
Yes, I'm having trouble with my camera right now, though.
We will just trust that you are raising your right hand.
I swear to tell the truth.
Thank you. I believe that was everyone, unless I've missed somebody.
All right. Thank you, AG Mercer. Thank you to the witnesses. Mr. Ryan, I believe that at this point, it's time we will hear from you, your presentation with your witnesses.
All right. Well, good morning, commissioners, staff, and members of the public. My name is Julia Ryan, and I'm a shareholder at Braunstein Hyatt Farber Schreck, and I'm appearing today on behalf of Bayswater Exploration and Production LLC, who will be presenting its Onyx Pad OGDP application. We want to thank our OGLA specialist, Melissa Housey, for her clarifications, and we appreciate the support of the relevant local government, Weld County, and Mr. Maxey for his remarks today. Bayswater is really excited to share its Onyx application with you and explain how its location selection and its many BMPs avoid, minimize, and mitigate impacts. I'm now going to turn it over to Ms. Walsh, who is a landman and senior regulatory specialist, who is going to introduce the rest of the Bayswater team. You just got a quick preview of that, and she will be leading the presentation. And I'll just remind to mute for the rest of the team members. All right. Oh, great. And now I will hand it over to Ms. Walsh.
Thank you, Julia. Can you all see my screen right now?
Yes.
Great. Okay, so we'll go ahead and dive in. As Julia mentioned, my name's Lauren Walsh, and I'm going to present our Onyx Pad OGDP today. So we brought a large number of subject matter experts today so that we're able to answer all of your questions in depth. So here today we have Steve Struna, who's our president and CEO, Tyler Hammond, our district landman, Robert Carney, completions manager, Jeff Overman, drilling manager, Ryan Kaminsky, facilities and production manager, Brad Rogers, EHS manager, and finally, Ann Feldman, our regulatory consultant. I'll take you through several topics regarding this OGDP today, including a company introduction and overview, proposed location, including the OGDP map, 304 B2B ALA criteria, as well as an alternate location analysis, permitting, as well as operations timeline, best management practices, including noise, light, traffic, air, cumulative impacts, and water resource protection. And I'll also review the CDPHE standard list of BMPs. We'll continue with local government partnership and community, as well as a summary in our requested relief. To begin, I'd like to go over an introduction to Bayswater, our team, our business values, and our commitment to sustainability. Bayswater was established in 2004. We have a 36-person headquartered office in Denver and a 16-person field office in Eaton. We also operate in West Texas and have a 10-person field organization in Coahoma, Texas. Our business values include having a long-term business perspective, which is evident by the fact that we have been an active DJ driller with a continuous one-rig program from June of 2017 until June of this year. And we've had a continuous one completion crew since October of 2020. We have drilled over 280 horizontal DJ wells, and also have plugged 81 of our 97 vertical well inventory. We're additionally very proud to say that we fit into an option 1 financial assurance operator designation. We strive to maximize value for Bayswater and the communities in which we operate through operational excellence and a strong mutually advantageous business relationship. In fact, the Onyx pad will contribute to beneficial cumulative impacts to the surrounding communities, including royalties paid to local Weld County mineral owners and contribution to local employment opportunities for individuals as well as vendors during pre-production and production phases of our operations. Finally, we have a strong commitment to sustainability and believe that the development of oil and natural gas and the stewardship of a pristine environment are not mutually exclusive. We know that affordable and reliable energy is vital for the US and the world. And we also know that we require a social license to operate. And we work hard to gain the trust of the communities where we operate to ensure that our actions always reinforce that trust. Here you can see the proposed OGDP map. This includes our DSU, WSU, as well as OGDP boundaries. We plan to develop this entire area from a single location with 12 wells in order to minimize surface disturbance. Also, please note that each of these proposed laterals will be more than 2.5 miles long. This exhibit depicts the Onyx pad proposed location. As you can see, this is a very rural area in Weld County, and it only meets one of the ALA criteria, that it's within 2,000 feet of 3 RBUs. Bayswater has received informed consent from each of the owners and tenants of these 3 homes. Also, as noted in the director's recommendation, not only is the location not within a DI community, but is not proximate to a DI community. In fact, the closest DI community is over a mile away, and the closest RBU, school, or HOBU within a DIC is over a mile away. The director's recommendation also supports the proposed location, noting, after reviewing the 11 alternative locations, staff determined that there is no single location from which the mineral area could be developed that would avoid potential impact to receptors. Additionally, this location will be tankless, only utilizing the existing facility at the Bayswater operated Leffler 26A pad, which is located directly north of the Onyx pad. Also, oil pipeline is already connected to this. We'll also be utilizing the existing access road from the Leffler location. Additionally, as part of the OGDP, Bayswater commits to plugging 6 horizontal wells and 3 vertical wells, all currently low producers. To give you a little bit more information, these P&As will include the reclamation of 2.95 acres of land. And please note that our proposed location, or that out of our proposed location and the 11 alternate locations, the proposed location and ALA number 1 and 2 are the only locations. Sorry, just one second, are the only locations where Bayswater could plug the 6 horizontal wells. That is because the 6 SRC Leffler horizontal wells, while low producing, older wells are still economic to operate today. Drilling the Onyx wells from the proposed location or west of the DSU would cause significant downhole interference during drilling and completion, which would require subsequent reworking operations. Instead of electing to undertake these operations, Bayswater sees that plugging these wells is the better option at those 3 locations. This exhibit depicts the OGDP boundary in purple, the proposed Onyx location in orange, and the 11 alternate locations that were considered in blue. To note on the commissioner's previous comment, I want to point out the ALA location number 2 shown on here was the one that was discussed in the Weld County pre-application meeting, and that was added from the locations that were originally considered after Weld County pointed out that it's a feasible location. So I'll take you through a high-level overview of the advantages and disadvantages of these alternate locations. I know that there's a lot of sites, but we take the ALA analysis very seriously, recognizing the hierarchy of avoiding, minimizing, and mitigating impacts. That being said, because we analyzed 11 sites in detail, I'll be moving pretty quickly, but I'm happy to go back and discuss in more detail any location that you would like at the end of the presentation. ALA number 1 is the existing Leffler 26A pad, Some advantages are this is an existing location, not within an HPH, mapped wetland, or DIC. Some disadvantages are that there are 7 RBUs, including 2 between 500 and 1,000 feet, which could cause significant cumulative impacts. Additionally, there are significant downhole anti-collision issues with existing wellbores, causing operational concern from this location during drilling. And finally, there's insufficient space to fit all 12 wellheads, which would cause safety concerns during production. Next, ALA number 2. Some benefits are that there are no school facilities, childcare centers, RBUs, or HOBUs within 2,000 feet. Location is not within an HPH, and there's no DIC within 2,000 feet. Some disadvantages we found here were that the location is upgradient from a mapped wetland, and it's within a center pivot of an irrigated field. Additionally, technically, this location is not feasible to drill all 12 wells from and would require 2 pads, increasing surface disturbance. ALA 3. Advantages are no school facilities, childcare centers, RBUs, HOBUs, and it's not within an HPH or upgrading of a mapped wetland or within 2,000 feet of a DIC. Some disadvantages include that the surface owner is not agreeable to signing an SUA for this location due to the proximity to his center pivot. This location would permanently disturb the surface owner's agricultural operations. And due to the existing infrastructure, adding oil and gas pipeline takeaway would have been extremely difficult to this location. ALA number 4, no school facilities, childcare centers, RBUs, or HOBUs within 2,000 feet, not within an HPH, upgrading of a wetland, or within 2,000 feet of a DIC. Disadvantages are surface owner has concerns about the location and impacts to his existing water wells as well as irrigation ponds. The location is not large enough to develop all 12 wells for the entire DSU, and there are multiple operational difficulties with this PLAD, including insufficient space for an access road and difficulty to run pipeline to location. ALA number 5. Advantages include no school facility, childcare centers, or RBUs, or HOBUs within 2,000 feet. Location is not within an HPH or upgrading of a mapped wetland, and there's not a DIC within 2,000 feet. Disadvantages are that we do not believe that we would be able to get an SUA because the location would disrupt a center pivot irrigation and feedlot. The only viable access road option would offset an existing RBU and cause significant cumulative impacts to the home. Also, an additional surface location would be needed to develop the entire DSU from here. Moving on to ALA number 6. There are no school facilities, childcare centers, RBUs, HOBUs within 2,000 feet. The location is not within an HPH or upgrading of a mapped wetland, and there's no DIC within 2,000 feet. Key disadvantages are the only viable access road is directly offset the surface owner's home, and the center pivot is used for agriculture. Because of this, we do not believe that we would be able to get a surface use agreement for this location. Additionally, we would need a second surface location to develop the entire DSU. Moving on, ALA number 7. This location is unique because it's a location that was previously pursued by Bayswater to develop a smaller DSU. We completed the WOGL permitting process, but ultimately abandoned the permit because of the desire to develop a larger DSU, including these lands. Also, a new home was built in close proximity to the location after our initial planning. Advantages here are that there are no HOBUs, school facilities, childcare centers within 2,000 feet, and the location is not within HPH or 2,000 feet of a DIC. Disadvantages include that the location is immediately upgradient of a mapped wetland, that there are 3 RBUs within 2,000 feet, including 2 between 500 and 1,000 feet. And Bayswater did not believe that it was possible to receive informed consent from these parties that are less than 1,000 feet from the working pad surface. Also, access to location would be near the closest RBU, creating substantial cumulative impacts. I've combined ALA 8A and 8B here because they are directly adjacent from each other. So I'll start with key advantages for 8A. There are no school facilities, childcare centers, RBUs, HOBUs within 2,000 feet, not within an HPH or within 2,000 feet of a DIC. Disadvantages are that the location is within a floodplain and immediately upgradient of a mapped wetland. Location would cause disruption to current agricultural operations. And so we really don't think that we would be able to get an SUA for this location. The access road would also be directly offset multiple RBUs as close as 143 feet, which we think would cause significant cumulative impacts to those homes. An additional surface location would also be needed to develop either of these. So 8B has the same advantages and disadvantages, with the only exception that it's not within a floodplain. Moving on, key advantages of ALA number 9 are that there are currently no school facilities, childcare centers, RBUs, or HOBUs within 2,000 feet. However, representatives from the town of Eaton have expressed their dislike for this location because it's owned by a housing developer that recently had this location as well as the surrounding lands annexed into the town of Eaton. There are plans for multiple single-family homes in the pink hatched area shown in this map. Finally, ALA number 10. Key advantages include that there are no HOBUs, RBUs, school facilities within 2,000 feet of the working pad surface. It is not within an HPH or 2,000 feet of a DIC. The largest disadvantage of this location is that representatives from the town of Eaton were consulted and do not support the location due to its proximity to Eaton city limits, shown in pink hatch on this exhibit. Additionally, the Eaton Town Recreation Center, including 4 baseball fields, are about 2,050 feet southeast of this proposed location, which you can see in this image in the pink hacked area here. Okay, now that we got through that, moving on to the Onyx Pad permitting timeline. One key step was our formal consultation with ECMC that occurred in August of 22. This consultation was completely voluntary, and we requested to ensure that we were going to get the right path in applying for a new OGDP. Our approved local permit, the WOGLA, was received in February of 2023 as well. This is our estimated operations timeline. We'd start in the fall if this application is to be approved. One item to note is that based on this schedule, Bayswater would be drilling the Onyx wells outside of high ozone months. Bayswater prides itself in being best in class with our best management practices, some of which we have included here. For noise and light, a baseline ambient noise study and noise impact assessment have been completed. As a result, 32-foot engineered sound walls will be utilized around the perimeter of the pad to dampen noise and minimize light to offset building for drilling and completions. 16 feet of permanent sound walls will be installed around the production facility vapor recovery units. Also, a quiet frac fleet will be utilized for completions operations. All lighting will be directed downward and inward and shielded to avoid glare on RBUs and to remain below the maximum permissible lighting level. For traffic mitigation, the proposed Onyx pad is designed to have 0 new oil tanks. The Leffler 26A pad is connected to natural gas and oil pipeline takeaway, which will significantly reduce truck traffic. All water utilized for hydraulic fracturing operations will be pumped to location via canals, ditches, and transferred via pipeline, thereby significantly reducing truck traffic for hauling water by up to 3,000 truckloads per well. All traffic will immediately be routed to County Road 33, which is paved, reducing dust associated with driving on dirt roads. Many of our BMPs are also geared specifically towards reducing air emissions. For air quality improvements, those BMPs include performing a baseline air monitoring survey prior to commencement of construction. An odor neutralizer is to be utilized in the drilling fluid to reduce overall odor intensity. Aromatics will also be mitigated by utilizing a closed flowback tank, with all water and gas vapors being sent to a temporary ECD during flowback period. Sandbox technology will be used to significantly reduce sand particulates from the air, and there will be continuous air monitoring of the location during drilling, completions, flowback, and this will continue through the entire life of the well. Bayswater's field-wide plan includes routine LDAR and AVO inspection as required by CDPHE with associated repairs if necessary. As I mentioned in our previous slides, Production facilities on this location are designed to have 0 oil storage tanks and currently connected to natural gas as well as oil pipeline takeaway. To further reduce cumulative impacts, Bayswater will plug 6 low producing horizontal wells and 3 low producing vertical wells. We also have a number of water resource protection BMPs in place at every Bayswater facility, including the Leffler 26A, where the Onyx well oil and gas will be flowing to. These include primary containment, which are the tanks, secondary containment, which are the liners, tertiary containment, which are berms, and we also have a field-wide stormwater management and spill prevention plan. This is in place to mitigate and manage all surface disturbance areas and any potential of spill. We want to proactively address CDPHE BMPs referenced in the director's recommendation that staff indicated we could not commit to or fully commit to. For background, there was no formal consultation between CDPHE and ECMC under Rule 309F, which is why there's no CDPHE consultation letter accompanying the director's recommendation. CDPHE also never formally requested a consultation with Bayswater about this location. However, ECMC staff provided Bayswater with a standard list of CDPHE BMPs going beyond what is required by specific ECMC rules that CDPHE asked all operators about. Sorry, it's a lot of acronyms. In the Bayswater response spreadsheet referenced in the director's recommendation, Bayswater committed to the vast majority of CDPHE standard BMP lists, but there were 4 noted in the director's recommendation that Bayswater couldn't commit to or could not fully commit to. One of these is whether Bayswater could commit to reducing certain activities and operations on forecasted high ozone days. Bayswater noted in the BMT spreadsheet that it would reduce certain activities and operations on forecasted high ozone days when operationally feasible. I appreciate that the commissioners try to avoid changes to BMPs on the fly at hearings, but to provide more specificity and firm commitment to the commission as to what that means, I'd like to clarify today and commit to you, Bayswater would have no issue with adding a BMP, providing that Bayswater will delay routine and non-essential operations that use fossil fuel powered ancillary equipment on high ozone days. Another issue is the electrification of production facilities on the Leffler 26A location where the Onyx wells will produce to. As noted in the director's recommendation, Bayswater will use electric power for a portion of production operations. However, Excel's overall power distribution system does not have enough capacity for our area to support any additional loads to Leffler 26A facility. Regarding electric drilling rigs and Tier 4 engines for drilling, electric drilling is not an option because there's not enough highline power for Excel. Additionally, we cannot commit to using Tier 4 engines for drilling, although we are using them for completion operations and have committed to doing so, because Tier 4 engines for drilling are very scarce. However, not being able to commit to using Tier 4 engines for drilling doesn't mean that Bayswater won't try to use the Tier 4 engines. Bayswater will explore the lowest emission option for drilling at the time of vendor procurement. By this, I mean that Bayswater will try to procure Tier 4 engines, and if unavailable, we will search for dual fuel Tier 2 engines. The last BMP not required by ECMC rule I would like to address is Group 3 drilling mud. Bayswater believes that the use of Group 3 drilling mud has the potential to cause downhole mechanical risk, which could potentially increase pad occupation time. However, if ECMC requires Group 3 drilling mud to approve this OGDP, Bayswater will commit to the addition of the following BMP. I know I've spent a lot of time on this slide, so thank you for bearing with me. I just wanted to spend this time to emphasize that Bayswater really does our best to go above and beyond ECMC rules when it can, but we just can't always do so. To the extent that there are impacts from the proposed location that cannot reasonably be avoided, the siting of this location ensures that there are few receptors to potentially be impacted. Finally, Bayswater is committed to being a good neighbor and to building long-standing relationships with key stakeholders, including municipalities and their residents. While the Onyx pad is outside of any city limits, it is nearby 3 cities, Alt, Eaton, and Severance. Bayswater is highly engaged in each of these communities. Some of the government and community engagement over the past year is outlined on this slide. In conclusion, Bayswater believes that the proposed OGDP is a strong application because informed consent was received for the 3 RBUs within 2,000 feet, and Bayswater uses first-class comprehensive BMPs, including 0 tanks at the oil location, at the Onyx location, and no new tanks at the Leffler location. Maximum electrification to production facilities, Tier 4 engines and a quiet frac fleet utilized during hydraulic fracturing. And we have committed to plugging 6 low-producing horizontal and 3 low-producing vertical wells. Also, Weld County, the relevant local government, is supportive of this application. And finally, that the director recommends this application for conditional approval. Please note that the COA listed in the director's recommendation reads as shown below. Bayswater agrees to this condition and will implement it in full. Now, I'm sure you've heard enough of me, so I will hand it over to Julia Ryan to address our requested relief.
Thank you, Ms. Walsh. So just to conclude here, Bayswater respectfully requests that the ECMC enter an order pursuant to Rule 307B1, approving the requested relief in Bayswater's amended application, namely to approve the Onyx Oil and Gas Development Plan, which includes approving a 1,640-acre drilling and spacing unit and a 440-acre wellbore spacing unit to have a total of up to 12 wells, all to be drilled from the Onyx pad. Thank you for your time and consideration of this presentation, and the team is available to answer any questions you may have.
Thank you. All right, we've got a panel before us and we've got commissioners, and we are at that stage of the game in which commissioners can ask questions. Who would like to initiate questions on this OGDP? Commissioner McGowan.
Thank you, Mr. Chair, and thank you for the additional information today. I think some of it helps answer some questions that I had. I'm wondering if we could take the presentation down so we can see each other better. Thank you. Okay, so I guess my first question is, I think we've all clarified there was no formal CDPHE consultation for this location, and that some of the BMPs were, I think if I'm understanding correctly, were kind of transferred to or from the Garnet application that happened, I think last year, but I can't remember. Could you clarify CDPHE's role and the consultation that did or did not occur?
Sure, absolutely. So you're correct, no CDPHE consultation occurred for the Onyx pad. The only formal consultation that we've had was for our Garnet pad. And we did explain to CDPHE at that time that those BMPs were generally standard for Bayswater. But at that time, we did not mention the Onyx pad.
I'd like to add to that, please. Commissioner McGowan, also when we received the spreadsheet that's included as part of our 4A, we also wanted to make sure proactively that CDPHE didn't have any issues, even though there wasn't a formal consultation. So we corresponded with CDPHE last week, provided it again to them and just said, hey, let us know if there are any issues, and they didn't identify any issues. So although there was no formal consultation, we did reach out and to see if they had any input.
Oh, okay, thank you. So my first reaction when I understood that was a little bit of concern, because the Garnet is different from the Onyx. So I had to go back and look at my notes, and they're just like high level notes. But I think some of the BMPs that were committed to were different for the Garnet than for the Onyx, and in my mind, perhaps a little more protective. And so I'm not sure that we're really comparing apples to apples here. And I'm not sure we're really saying that we've committed to the same BMPs. I get that the list is kind of the same from CDPHE. And I at some point, maybe we can ask CDPHE to explain why they didn't provide a formal consultation in this case, because we do have 3 RBUs within 2,000 feet. We're in a non-attainment area. And I am curious to know, I guess, to hear from CDPHE that they have no concerns about this proposal and how it's been put together. So I'll stop there. I'm wondering if we could talk a little bit about the commitment to, we'll search for dual fuel if you have to use a tier 4. So what I think I'm hearing is we're again, I struggle with the I'm going to try and this might happen kind of language, because that's not really what then we can assess as part of our approval process. It's what you can commit to at the time of this conversation here and this review. And so I'm appreciative that, because I asked, and you all did directly consult with Xcel on this particular property, and the electric drill rig is not possible. In fact, if I'm understanding correctly, Xcel can't even provide enough electricity to fully electrify both pads, which was one of my questions that I sent to you all. And so I'm appreciative that, right, you tried, and you have the provider saying they can't actually provide it. So then the next step is, can you go to tier 4? And in particular, because you're next to 3, you're within 2,000 feet of 3 RBUs. What I'm hearing you say is tier 4 is not an option. And so then we go to tier 2. And so when you say we'll search for dual fuel, what do we mean? What are the chances? And is there a way we can get rid of squishy language, I guess?
I'll take that first and then kick it over to a subject matter expert. We talked about this at length in preparing for this hearing, and one of the reasons why we explain this instead of proposing that as a BMP was because acknowledging it's not, a firm commitment. It's that we're going to use our best efforts, and that's true, and that's what Bayswater could commit to. But it's important to us that we can commit to things that we can actually commit to, and also that it's very clear. And so that's why it's not a specific BMP, but we just wanted to explain the efforts. But in terms of what the company will be looking at, the goal is to explore whatever the lowest emissions option would be at the time. And I'll let a subject matter expert take that on. And then just before I do that, I would note that this stage of the project, if approved today, would be slated to occur in the fall or winter. So we would be out of those high ozone months. So we do think that that's a helpful factor.
Yeah, I think I'll step in here. Thanks everybody. Good morning. I'm Jeff Overman, the drilling manager, and I think our goal is the same here, to try and find the most low emissions rig. Although these technologies are just not easy to find, not available. So I think what we can commit to are the diesel tier 2 engines, but that we'll make every effort to find something more emissions efficient, and if something comes across, we'll jump on it for sure.
Thank you. I'm wondering, something that you all shared with me that I think might be beneficial to the other commissioners to look at is what will be electrified at both of these locations. I mean, I think the concern for me, even with informed consent, is that you have, I can't remember how many wells already exist at the Leffler, and then you're going to be adding 12 more directly, pretty much adjacent to that site, right by this RBU owner's home. And so that the production of those facilities, which will be for many, many years, will be what they will be exposed to from an emissions perspective. And so I'm wondering if you wouldn't mind sharing that information, because it was helpful for me to see.
I think maybe Ryan, is that more your area?
Yeah, I could address that. Thanks for the question, Commissioner. Yeah, so we have 13 existing wells at Leffler. based on, so Leffler was originally built back in 2020. We started conversations with Excel as early as 2018. Even at that time, they were limited in their capacity for electrical support for equipment. So we currently, just because of the size of our gas lift compression, we can power everything on site, including LAC units, VRUs, all our lights, all our low pressure or low voltage automation. The only thing we're unable to power is the large 1200 horsepower gas lift compressors. So everything else is electrified. It's only the large Caterpillar 3516 gas lift units that we are unable to support electrically.
Thank you. Is that something that you think would be a permanent situation, or over time, would you be willing to continue to work with the electric provider to see if that can be electrified?
I mean, it's something that in order to gain the capacity for the additional Onyx, because we're actually pulling off of the same line there, we had to work with Excel again the last year to kind of give up some capacity in other areas throughout the field. Because when we work with Excel, they save capacity that we commit to, which is good and bad. But yes, we're willing to. I know that they're working on a massive substation upgrade in this area. I don't have detailed timing. I'm hearing anything from 2024 to 2027 when we would actually see more available power. But that's something that, yes, we are, for other future pads, we're always looking at, increasing our electrification when the utility can provide capacity.
Thank you. So I think, and I'm thinking about emissions and the impact for those folks who are living closest to those two locations, right? The biggest emissions will be during drilling and completions. And then the rest that we think about is the long term, over time, and many, many years of production that will be right next to this person's home. And so I'm trying to think both short term and long term, how we can try to commit to minimizing emissions as much as possible on these two locations. And this is kind of a weird one for me, because you're not amending onto the Leffler. It's a second site, but you're doing things that are associated with the Leffler. And so it's hard for me not to look at it as a whole picture and what's happening at both of those locations, right? And so I guess my next question, and I also submitted this to you all, but I think it warrants discussion, is you have, I think, 14 oil tanks on the Leffler site, which are opportunities for additional emissions, right? I think part of the explanation as to why there's so many is that they're smaller than the tanks that we would normally see on site because of their age, I'm not sure. And then the second piece, which I don't find as compelling, is like, well, we don't want to shut down if something happens to the midstream operator. We need to keep producing. And I don't find that as compelling. So I'm wondering if you could talk a little bit about why you need 14 oil tanks on the Leffler site still.
Yeah, 14 was the original count from the original SRC Leffler. As the original 6 wells were drilled, we inherited that pad from another operator, and then kind of expanded the pad for the 13 Leffler wells. So we kept the tanks that were there. They are 300 barrel. We are running 500 barrel or surge style vessels on our newer sites. And yes, to your point, there are a lot of tanks there. If it's something that's important to you guys, we're willing to commit to removing that. I'd be willing to go down to as low as 8 oil tanks. We can remove those. That's a simple task during our retrofit work. I would prefer to keep some there just because we do use some operationally for testing and calibrations for our equipment. But something that, yes, we definitely be willing to reduce from 14 as we complete the construction work.
Thanks for that additional information. I think that would be a good addition to maybe consider. I'm done asking questions. At some point, Mr. Chair, I would like to hear from CDPHE and what's happening with consultation and why there wasn't a formal consultation.
Thank you, Commissioner McGowan. And anticipating that, we've elevated Ms. Sorensen and would recognize Ms. Sorensen if she, hello. Did you hear the question and do you have a response?
Yes, Mr. Chair. I am actually new to the energy liaison position, and we have been in the midst of a transference from the prior holder, Mr. Rick Coffin. So with the, I was not there for the beginning of this consultation process, but rather right in the middle here at the end. I did correspond with Ms. Walsh last week on the consultation with that about reviewing their BMPs, but there was no request done for a formal consultation. As to whose fault that is, I cannot say. But we have looked at the BMPs. We do have their responses, and I believe after further review of the BMPs, it certainly would help to consult with the operator, not necessarily in this venue. We've also since run an EnviroScreen score on this site.
Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Ms. Sorensen, for your for being here and providing additional information. Sorry, I'm not trying to place blame. It's just usually when we're near people and we're in the non-attainment area, we see a formal consultation from CDPHE, and I know you all have been in transition, so there's no blame here. I guess my thought is, after you've seen the presentation and the additional commitments from the operator from the conversation, does CDPHE feel that these are appropriate, adequate? Would you like a formal consultation? Kind of just trying to get a feel from CDPHE about where you all are. I think there were some things that were committed to today that from my perspective make this proposal better, and then also wondering if you could share the Enviro score, please.
Absolutely. So I'll start with the Enviro score first on that front, if you allow me, Commissioner. And so the overall EnviroScreen score here was 45. Our threshold is typically an 80 in terms of a DIC. There were 3 kind of potential concern scores in there. I won't share the entire list, although I have made that available to Ms. Larson to distribute to the commissioners. And so that is the air toxic emissions percentile is actually at 98.1. So that's very high in terms of the air toxics. Their drinking water regulation score was an 83, and the other pollutants score was a 97.9, other air pollutants, excuse me, as well as their proximity to oil and gas of 96.6, which is actually not surprising when we see that. So I think the big flags here for CDPHE are the air toxic emissions and the other air pollutants. So obviously this is an area which is very prone to those sort of pollutants being present. And so any of the efforts in the BMPs that could help remediate that, I think, are really important to us. I think CDPHE is very happy to see the offer to possibly use group 3 months on that for that reason. So that actually, so to answer your first question, I think CDPHE would be comfortable based on the answers in the presentation with that group 3 MUD recommendation.
Thank you.
Other commissioners with questions? And thank you for being here. Commissioner Messner.
Thank you, Mr. Chair. I don't have a question for Ms. Sorensen, but I do have some questions for the operator. So I wasn't sure if you were asking if there were additional questions from Ms. Sorensen or whether we were.
Why don't we just exhaust any questions for Ms. Sorensen while we have her?
Fair enough.
And there may not be any. You did a great job.
Thank you, Mr. Chair.
Okay. We'll let you go for now. We know how to find you if we need you. So thanks so much. Okay. And now I would recognize Commissioner Messner for questions to the panel.
Thank you, Mr. Chair. Just a point of clarification. I think I understand this, but I may not understand this. And so in the Garnett BMP, BMPs that were included in the Form 2A, they're included the utilization of Tier 4 engines for any non-road construction equipment. I can't remember if I saw that in your presentation or not, as far as something that you're committing to in this particular one. And so wanted to get a better understanding of that.
You know, I think I need to pull up our list. I'm trying to recall our answer to that specific BMP. Does anyone from Bayswater have that response in front of them?
If not, Ms. Walsh, we can give you and your team some time to pull up that information. I'm sure our Commissioner Messner has other questions, and we can let that one sit in the back pocket until you're ready to answer it.
Okay, sure. Let's do that. And I'll find the spreadsheet and have an answer. Apologies for not having that in front of me.
No, that's okay. I actually don't have any other questions. That was my question.
Okay.
And understanding that in lieu of a CDPHE consultation, which I really do wish we had, I think it's really important to have formal CDPHE consultations when we're in sensitive areas like this, irregardless of whether there's informed consent or not. But I want to, so therefore I'm hearing that we're applying essentially the Garnett BMPs to this one. And as Commissioner McGowan indicated before, there were more protective BMPs that were proposed for the Garnett one than are proposed for the Onyx. And you've gone through most of those and your reasonings for why you're choosing not to commit to those. But I want to just cross-reference and make sure that I understand if there are any other discrepancies. And so that was the only other one initially that I had noticed.
So first, I'd like to clarify that we did not represent that these are identical, and the only conversation that was had back in the CDPHE consultation for Garnet, which was our first consultation with CDPHE, and I believe one of the first CDPHE consultations. So we're all kind of trying to get our footing around us. We just told the CDPHE representative at that time that the BMPs that we submitted were generally standard for Bayswater. So the ones that have been submitted for Onyx are specific to this location. I actually have not done a direct comparison of the two because they are separate locations.
Okay, thank you for that clarification. You know, I do acknowledge that it is possible for the commission to request a CDPHE consultation if it's determined that it's necessary or not. And so I'm not saying that I'm going to do that right now, but I'm considering it because I think there's enough information that's being provided that, you know, may validate the need for a formal CDPHE consultation, since this is a separate location and it is, you know, a significant time difference between the Garnett approval and the Onyx approval, and that consultations have evolved during that time, including the utilization of EnviroScore. Although, I mean, I do acknowledge that a 45 EnviroScore is well below the threshold of 80. But I think that consideration of the air toxics is something. But I again, without a full consultation, I'm not sure that means that much to me, or it doesn't give me the full picture. And so I don't know. I'm thinking about that right now.
And thank you very much for your comments. We appreciate that. I was able to pull up our CDPHE commitment spreadsheet. So for row 20, which is operator will use tier 4 or better engines for non-road construction equipment, we did commit to that for the Onyx application. And then was there another BMP that you referenced as well?
No, that was the only one that I was confused about. And so I appreciate that.
If I may please add, I just wanted to say that although there was no formal consultation, the director's recommendation also does note that we told you about Bayswater's the informal consultation we had with CDPHE that Ms. Lawrenson just spoke to. But the director's recommendation also notes that the COGCC staff, your staff, also reached out to CDPHE And so I just wanted to make it clear for the record that although there was no consultation under Rule 309F specifically, the sister agency did speak with your staff and discuss the BMPs.
Thank you, Ms. Ryan. Appreciate your input. We'll also acknowledge that I'm an independent review body from staff on these applications, and so at times need the documentation associated with consultations to make my own determination.
Commissioner Cross.
Thank you, Mr. Chair, and excuse me, and thank you for the presentation today. I wanted to go over a couple quick questions. First, a point of clarification. You were talking about the ability to commit to a lower number of tanks at the Leffler location. And I think you said you could be comfortable going down to as many as 8. And I just wanted to make sure I understood that as well, because I believe you said that the tanks that were already on site are smaller than the ones used, and going down to 8, would that be replacing the tanks with larger tanks, or how would that be done?
Thanks, Commissioner. Yeah, the plan there would be to just keep 8 tanks there. So simply, disconnect the piping and crane out the old tanks. I don't think it's worth the effort of going through and hauling in new tanks. We typically we would plan to inspect those tanks to make sure that they provide adequate. There's no corrosion issues, because we have seen that with old tanks like that. But yes, my plan would be to keep the tanks there and remove and consolidate the containment so it's a smaller footprint.
Okay, perfect. I just wanted to make sure that the effort to get to 8 was not by switching the tanks as well. And I wanted to ask quickly, in talking about the Group 3 drilling mud, you talked about not using it at first because of the downhole mechanical risk. Can you go into a little more detail on that, please?
Sure, I'll grab that one. So earlier in the year, we had a pad that we had 2 rigs on, and one rig was using the Group 3s, one rig was using the Group 2s, and one rig had significantly more downhole issues than the other rig did, and it was the rig using the Group 3s, and it extended the time on wells by about half a day per well. So although we got the wells drilled, it did cause some downhole mechanical issues during drilling.
And when you talk about it, was it just a matter of it taking longer, or was there actual problems with the mechanics, the equipment, or what happened?
The problems caused it to be longer downhole with stabilization of the hole.
Interesting. And you were able to specifically narrow it down to the Group 3 mud being the issue with that.
It was the only difference between the 2 drilling programs.
Interesting. Okay, I just hadn't heard about the kind of mechanical problems with the Group 3 mud before, so that was interesting to me. Could you give us an idea of where the wells that you would offset with the plugging and abandoning would be, and are those Bayswater wells as well?
Absolutely. I actually have an appendix slide for this, so I'll share my screen to show you guys. Sorry, just one second. Okay. All right, can everyone see that?
Yes.
Yep.
All right, so as we mentioned, there are 6 horizontal wells that we're going to plug, as well as 3 verticals. So you can see the 6 horizontal wells in the picture to the left. So this is a drawing of the existing Leffler pad that's just north of the Onyx pad. So all of 6 of those wells would be on the eastern part of that pad right there. And we would also be able to reclaim that pad back by 2 acres. And so a great point to be able to mention here is that those 6 wells are in close proximity to 2 of the RBUs within 2,000 feet. So we do think that this would be a beneficial impact of the Onyx development. And then the other 3 are pointed out on the right side of the map. One is in close proximity to city limits that are the pink hatched area, and the other two are in the middle of cropland. And they're all operated by Bayswater.
Perfect. And you indicated that these were all low producing wells.
Yes, that's correct.
Do you have any concerns about the low producing wells off of the Leffler with you drilling additional wells this close by?
I think that's part of the reason that we are actually able to plug them is because they would need significant reworking after we drilled the Onyx wells. So it makes more sense to plug them at that point. But we think it would be fine to be able to get to the Onyx wells.
Okay. And then I do want to touch quickly on a couple points with the ALAs. If we could go to the ALA number 2.
Sure.
Which I believe is the one that you said was identified by Weld County there.
Yes, there you go.
So what I wanted to try and touch on is, as you talked about some of the disadvantages, you talked about the technical infeasibility of drilling due to the reach of more than a mile and the laterals going out more than 2.5 miles. Is that correct?
Yes, exactly.
Okay, and would there not be the same reach issues, the same step out issues with the proposed pad?
No, there would not, because it wouldn't need to cross that entire section there that you can see between the number 2 and the orange outline of the proposed pad. So while they would still need to backbuild a little bit, it wouldn't be nearly as significant.
And so I guess my question is not of the going across all the way across township 20 or section 26, 25, and 30, but are you also saying there's a feasibility issue with the step out to the southern part of those sections?
Got it. I think I'll let Jeff Overman, drilling manager, address that. He can get a little more technical on the drilling aspects than I can.
I think they're just longer from ALA 2. There's also some laterals that are landing going to the west, and so you're crossing those laterals where we can avoid them from number 1.
Okay, and do you know who are the laterals that you're going across from the ALA number 2? Are those Bayswater wells there, or are those from different operators?
Yes, they're Bayswaters.
I think those are my only questions at this time. Thank you.
Okay, further questions, Commissioner Ackerman? I see you.
Thank you, Mr. Chair. Appreciate the opportunity to ask a couple of questions and appreciate this application. And I think the majority of what I has been focused on already, but I did want to talk a little bit about the number of CDPHE proposed BMPs that had a commitment, but when operationally feasible. And I think in some of those I understand, but I wonder if you could elaborate on a couple of those. One of those is the elimination of the use of VOC paints and solvents. One of them is, leaving vehicle engines idling. And, it concerns me to see so many that are, when operationally feasible. We've talked about this quite a bit in the past, that, when operationally feasible essentially provides an exception whenever you feel like it, to be blunt. Can you talk a little bit about when the use of VOC paints and solvents is necessary, and why you could commit to something like that, or when the leaving of vehicles idling is necessary, and so you wouldn't be able to commit to that?
Thank you for the question, Commissioner Ackerman. We were just identifying on our team the correct subject matter expert to answer that.
Yeah, I can answer some of those questions. As far as the operationally feasible language that we've done there is We've committed to, there's certain sorts of maintenance items that we need to do, whether it's, if there's clean outs or ECD maintenance that is required. That's those kind of things that we can control and plan. Say we're doing a separator clean out or a tank clean out or some sort of maintenance activity that we do plan. We're willing to delay that. That's a quick, easy delay. Push it back a few days, a couple weeks. Not a huge deal. Things like if there is an urgent need for operators to access a well during weather conditions or upset condition that happens on pad, that's when we're going to say not feasible. If there's an urgent need for an operator to address, whether it's an alarm, we get text alerts for tank levels, alarms, pressure, lots of things. If we ever have that and it's an urgent reason to get on the pad, there's a reason why somebody may be leaving the vehicle running, or at that time, refuel in the middle of the day to go back out to a site. Or there's times where, we need to complete maintenance activities in order to avoid whether, it is a minor spill and containment or things like that can happen. We are going to address those immediately versus delaying them, like some of the other maintenance or pre-planned preventative maintenance items. So that's kind of what we've tried to define as the operationally feasible.
Thank you for that response. And with there being so many that are when operationally feasible, would you be willing to consider a reporting criteria that reported when you found one of those to not be operationally feasible and just were able to submit that to staff? Is that something that you would consider?
Yeah, I think we'd have to discuss more in detail about how we would track that. I know that's a conversation we've had, that it's hard to track when something comes up, at midnight and there's guys out there. But I think it's worth more conversation on our end of how we can find a way to track that. I mean, I know there are ways we track all of our other daily checks through software that we have. So I think we can look into that.
Yeah, thank you. And I certainly understand the need for operational flexibility to deal with the dynamic work environment. I understand that is important. And I also equally understand that if there's a catch-all, that it's easy to default to the easiest method as well. And so I'm trying to find a balance between really holding us to making those exceptions only when it's absolutely necessary rather than when it's convenient. So I appreciate you being willing to think about that.
Commissioner Ackerman, sorry to interrupt you. I think we are willing to commit to that tracking that you've requested.
I appreciate that. Thank you. I would be very, very interested to see how that goes, and really appreciate you being willing to undertake that. Thank you. And then this is more of a comment than a question, and I appreciate the consideration of the lowest emissions drilling equipment, which of course is something that we've talked about a lot. And certainly if you listened during the last hearing, last item that we had in this hearing, and wondered if you had made already proactive efforts to kind of set forth a pathway for potential electrification and or potential acquisition of Tier 4. I think I heard a lot of discussion during this hearing of we will seek to find the best equipment, but are there actions that have taken place already, and do you have that on track in any way?
As far as the drilling rig goes, yeah, I've talked to many drilling contractors, and they're just not available. I'm hoping the answer is not available yet and it's coming, but yeah, as far as tracking goes, a lot of it has been, verbal conversations trying to see what's available, and but we can surely track that and get more documentation on that.
Thank you. I appreciate that. And I recognize the reported rarity of that type of equipment. And it does seem that those that are able to get it lined up quite a ways out are able to acquire that. So I appreciate those efforts. Mr. Chair, that's all I have. Thank you.
Okay, great. Kind of a global question for the applicant. I've heard that, you know, between application and kind of where you are right now today, that there's been changes or better BMPs that are committed to, but I'm kind of lost in the fog as terms of like what's actually on the table today. I also know, or I have a feeling just from listening to Commissioner McGowan, that she may have provided you with some questions and you may have answered some of those questions. I don't know that I've ever seen that. And so as you collate a list of, you know, where you're at today, be worthy of that. And I may just have missed reviewing it, but I don't recall seeing that. And I think it's important for all the commissioners to have all the information before us. So that's kind of a setup to you, Ms. Ryan. And I don't know if you're able to kind of walk me through it so that we can get a sense of kind of where we're at right now, or if a little bit of time would be helpful. But I will lodge a question mark behind my utterings.
Sure, thank you. I've done my best to keep track. I have 3 buckets of additional items that would be new commitments. This would be Bayswater going down, you know, if this would please the commission, Bayswater could go down to 8 tanks from the existing 14 tanks on Leffler. Bayswater could use group 3 drilling mud. And we can agree to track on those rare instances where it's not operationally feasible to commit to some of those BMPs that Commissioner Ackerman just mentioned.
Okay, thank you. Thank you for that. Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Ms. Ryan. I'm wondering also, I think one of the questions I had about what was getting P&A'd and what those emission savings might be was because I felt like the Form 2B was kind of incomplete and had different information that was in the narrative in some other places in the application. I'm wondering if the operator is open to a BMP to amend their Form 2B to update information about how many wells and associated equipment will get decommissioned, I guess I'll use that word, and an estimated emission savings from that activity and reduced truck traffic trips. We're trying to keep track of all this for our cumulative impacts information, and I think there's a nice tie to when operators are committing to decommission equipment. We're trying to track what that savings is.
Yes, I've heard from the team that that's something that that Bayswater can do.
Thank you. I'm sorry, Mr. Chair.
I'm sorry, did you have something else, Commissioner McGowan?
Yep, I would like, I feel like when we say, well, we're going to trust the operator, you're going to try your hardest to do this thing that you can't commit to, we never hear back and find out what the thing is. I would like to know in the end, what kind of engine is being used for drilling for this project.
Do you propose that as an additional COA, Commissioner McGowan?
Yes, thank you, Mr. Chair.
Okay. Noting that our Attorney General Mercer has visualized herself, I would recognize her.
Thank you, Mr. Chair and Commissioners, and thank you, Ms. Ryan, for clarifying the additional commitments that have been made today. I had a couple of other items that are on the notes that I've been taking, so I was hoping to just clarify whether my list was correct. So I have the 3 commitments that Ms. Ryan stated: the reduction of tanks, the group 3 drilling fluid, and reporting when it is not operationally feasible to implement some of the BMPs that are noted. I also, in addition to those 3, noted the BMP that was shared on one of the slides that says operator will delay routine and non-essential operations that use fossil fuel powered ancillary equipment on high ozone days. They also have committed to, or they've agreed to the condition of approval in the director's recommendation. And then, so those are the two other commitments that I had. And then I had a couple of questions. One being that, on the Form 2A, the commitment to using Tier 4 engines for fracking is in the bucket of things that will be done if operationally feasible. It seems today, or I seem to have heard today, more of a firm commitment to the Tier 4 engines for fracking. So I thought it would just be helpful to clarify for the record whether that is in, unconditional commitment or if they will be used if operationally feasible.
Yes, happy to clarify. And thank you for mentioning those other two as well. Since we covered those in the slides, that's just why I didn't mention them, but thank you for being thorough and comprehensive. To your most recent question, yes, the use of Tier 4 for completions is a firm commitment. So we'd be happy to clarify that and make that solid.
Thank you. And then just a couple other clarifying questions, if I may, Mr. Chair.
Yes.
With respect to just to help staff and the operator in crafting the language for these commitments, to Commissioner McGowan's last request, which is that the operator will provide a report of what type of engine is ultimately used for the project. Is that something that should be conveyed to staff or directly to the commission?
Commissioner McGowan.
Thank you, Mr. Chair. I think both, please.
And something like just submitted via email to the staff and commission. Is that what you'd are envisioning? Okay. Great. I'm just looking to make sure whether I have any other questions here. Sorry, one more moment. And is that, it sounds like that's just an informational request, Commissioner McGowan, versus something that you'd be looking to approve or deny at that time?
Correct. We keep hearing the try, and I just actually want to know what happens when people say they're going to try.
Understood. Thank you. I think those are all of my clarifications for now. Thank you, commissioners.
Thank you, Ms. Mercer, for being comprehensive there. Further questions listed as a result of this last bit of discussion? Okay. I guess I have kind of one final question, and it pulls off of something Commissioner Messner had been discussing, and that has to do with the CDPHE, I guess, lack of consult. And it's a question for the applicant as well as potentially for Ms. Sorensen. It seems like normally if we've got RBUs within 2,000 feet, we generally have a CDPHE consult, and we've got 3 in this instance with informed consent. But we have, I think what the narrative is telling to me is that despite the lack of formal consult, the applicant did review the general list from CDPHE against the application and generally committed to, most of those things and provided an explanation as to the ones that were more technically feasible. And then Ms. Sorensen, I don't want to put words in your mouth, but I think that your testimony is that, with all of that happened, even if it's not kind of the normal process of an actual formal consult, but that CDPHE, given the EnviroScore and given the commitments and given the Group 3 MUD commitment today, is comfortable with the application. But again, I just wanted to give you an opportunity to maybe clarify that.
Thank you, Mr. Chair. Yeah, so some detailed backgrounds to answer your question first. I think with what has been presented today, if it had been presented in a consultation, that would have been our result, yes. Should we, I think if it were to be done again, repeated, or at a future project, CDPHE is always interested in doing a formal consultation if there are any RBUs within 2,000 feet, and if it is in a DIC, either or. So I think that is of interest to us for sure. In this particular case, we were contacted by COGCC on June 21st, and we never said we did not want a formal consultation. We just never said we did as CDPHE. That's something that will be corrected in the future for sure. But you can be assured that simply to streamline the process for the commission and to provide the most knowledge available to the commission from CDPHE, that if there is an RVU within that or in a DIC, we would definitely be interested in doing a formal consultation with the operator.
Okay. No, thank you for that clarification. I think it's helpful for the record going forward and helpful for the record on this particular application. So appreciate your involvement with us this afternoon. It's afternoon now.
That's why we're here.
Appreciate that. Okay, further questions for anyone? Commissioner Cross.
Thank you, Mr. Chair. I just wanted to follow up with one question on the request for the WSU. Is the area where the WSU is being proposed, is that where some of the 6 laterals are that are going to be plugged and abandoned, or are those wells further north from that?
So the 6 wells that are the 6 horizontal wells that are going to be plugged and abandoned actually go from the SRC Leffler pad south. So they do not go north into the WSU.
Okay, so the WSU is just mainly there because you're right by the border for one of the well bores that's being proposed. Is that correct?
I believe so. Tyler Hammond, our district landman, could probably speak more to that.
I apologize again, my camera is still not working, but that is correct. That well offsets the section line very closely, and that is placed there due to there was never a modern horizontal well on the other side of that section line, so we tried to get one as close as possible to drain that extra acreage up there, as there's only older horizontals there.
Okay, perfect. Thank you.
Thank you, Commissioner Cross. Further final questions? Okay, thanks to staff and to the panel. At this point, we move into the deliberations section of this permit application. Does anybody desire to initiate deliberations? Commissioner McGowan?
Thank you, Mr. Chair. So I'll start. So I'm definitely appreciative of some of the additional commitments that the operator is willing to make to reduce emissions, and I think the impact to the closest neighbor and the other 2 RBUs. I'm appreciative of that. I'm really hoping that we can do better than 2-tier diesel. So looking forward to seeing what that response is. I think this is an approvable permit. I think the additional commitments make this a better permit than what was originally submitted, and I'm appreciative of that.
Thank you for initiating, Commissioner McGowan. Commissioner Messner?
Thank you, Mr. Chair. Thank you, Commissioner McGowan, for going first and leading us off. So I want to start by providing appreciation for the quality of application that was provided. I thought it was well organized. I thought the alternative location analysis was excellent. I thought that it was a very thoughtful application. And so a lot of the boxes were checked on this application that that I really appreciate in my review. And there was a couple of boxes that weren't checked that have been talked about today. And I appreciate Ms. Sorensen from CDPHE committing to formal consultations in the future. I think as an applicant, I would proactively request a CDPHE consultation, if there was any concerns, just to not have to go through this at hearing. At the same time, that may not be a problem moving forward because of the commitment from CDPHE. The reason that I ask for that independently as a commissioner is that I am not a public health expert, and CDPHE is my public health expert in reviewing applications to determine whether they meet the protection of public health and of the environment and emissions profiles and these types of things. And so that information provided from CDPHE to me is really important, particularly when we're talking about RBU units within 2,000 feet or other sensitive receptors. I think it's really similar to the way that we utilize consultations with CPW to determine potential impacts to wildlife and wildlife habitats, and you know, the formal process of that. And you know, I'm not a wildlife expert, so having that formal consultation with the state agencies that do have that expertise is really important to me. And so now, having said that, through this process and in conversations now with Ms. Sorensen, and you know, it does appear that the BMPs that are being proposed from her perspective and CDPHE's perspective are appropriate BMPs for being protective. I you know, acknowledge the informed consent and RBU owners being able to make a determination whether or not they feel like operations around them are protective, independent of decision making here. And so, you know, the operator got informed consent, and I think that's a strong step. But my comments from the previous application still stand to this application as far as overall, you know, efforts around NOx reductions and best management practices moving forward based on intent of future activities that will occur. And that doesn't mean that I can apply those here, just like I couldn't apply them in the last application. But I think that, you know, an industry that prides itself in technological innovation in order to overcome challenges and meet emission standards and environmental best practices, I think that there are better technologies available than what's being considered specifically for the drilling rig in this situation. I think other things that are being committed to are strong. And I really appreciate that this operator is choosing to state that they aren't just going to hang their hat on the initial proposal of what they can commit to today, but are going to continue to look at not only the accessibility of Tier 4 diesel engines for drilling, but other technologies, other innovation, other opportunities to reduce emissions in order to be able to you know, proactively take steps towards, you know, what now are not required NOx reductions, but soon could be required NOx reductions moving forward, understanding that these applications that we're approving today, you know, while construction timelines indicate that they may happen in 2024, end of 2023, there's no requirement in these applications that those occur during that time. So it could just as easily happen in 2025, 2026, when there is going to be updated requirements for NOx and emission reductions. And so it will make it more difficult for industry to meet those targets if we're not taking steps today. And so that's just my little soapbox piece there again, but I do think that this application at its core meets the requirements of our rules, and I appreciate the effort, and I really appreciate the alternative location analysis on this one. I think it was exceptional. So those are my thoughts.
Thank you, Commissioner Messner, for those thoughts. And your and I agree with you. I think that the application was well done. I thought the ALA analysis was very good, and with the commitments we received today, as well as the work that's been done on this via staff, I'm comfortable that this is an approvable location as well. Commissioner Cross, Commissioner Ackerman, any deliberative thoughts? Commissioner Cross.
Thank you, Mr. Chair. I'll just be brief because I think my thoughts have been said already. I did have some questions coming into this, but I do think that the commitments made by the applicant here are helpful to it. I am appreciative of Ms. Sorensen being here, especially being new to the role and being here and providing input on it. I also thought the ALA analysis was very good. I feel like the walking through it, and other operators do it as well, but I feel like walking through it and specifically talking about the different issues provides not only to the commissioners, but to the public a better understanding of why certain locations are chosen. And so I do think that's important. And yeah, I also think that this is an approvable location.
All right, with that, do we have a motion?
Move for approval with the conditions of approval and that were mentioned during the hearing today. I don't know if Ms. Mercer, if it makes sense for us to run through them all, but the ones discussed by you earlier.
Okay, before we get a second, let me ask Ms. Mercer what her thoughts are as to the form of the motion.
Thank you, commissioners. I would like to take the opportunity to clarify it because I did track one other commitment that was made that I did not summarize in my earlier statement, which is that this was one requested by Commissioner McGowan that the operator said they could agree to, which is that the operator will work with staff to ensure that the Form 2B accurately reflects the contemplated wells and associated equipment that will be decommissioned, including with emissions reductions estimates. So I would add that. And so what it sounds like we have is a motion to approve the application with the addition of the following commitments. First, the one that I just stated, that operator will work with staff to ensure that the Form 2B reflects the decommissioned equipment and wells, including emissions reduction estimates. Second, it would include the condition of approval as stated in the director's recommendation. Third, it will include a COA requiring the operator to reduce the tanks on the Leffler pad from 14 to 8. Fourth, that the operator commits to using Group 3 drilling fluid. Fifth, the operator commits to using Tier 4 engines for completions with no caveat for whether doing so is operationally feasible. Sixth, that the operator will track any instances in which BMPs are determined to not be operationally feasible and will report that information via email to both the commission and staff. I think we're on number 7. The operator will delay routine and non-essential operations that use fossil fuel powered ancillary equipment on high ozone days. And number 8, the operator will report what type of drilling engine will be used for the project via email to the commission and staff. And I would add that if the operator utilizes a different type of engine than indicated in their application, the operator will need to work with staff to update the Form 2B accordingly.
Thank you, AG Mercer. Commissioner Cross, does your motion echo the points made by AG Mercer in terms of conditions?
It does indeed.
All right, do we have a second?
Second.
Motion by Commissioner Cross and second by Commissioner Ackerman to approve the application with the reference conditions. Before we take a vote here, I want to recognize Ms. Ryan. We've got a kind of final articulation of conditions. Does that comport with you and your client's understanding of where things stand?
It does, and thank you for the opportunity to confirm.
Thank you. Okay, further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Docket 221100310 is approved with the aforementioned motion conditions. Thank you very much to the panel. Thank you to the commissioners for the good questions and deliberation. Thanks to staff for the good work, and thanks to CDPHE for being here with us today and providing a lot of good comment. And we look forward to having you with us often as you venture into your new job. So appreciate that. Commissioners, we've got one other docket on our one other thing on our docket. It's an enforcement docket. I do not think it's going to take a tremendous amount of time. I would suggest we just hammer through and get her done. Is that okay, or do folks want to take a break for lunch? Commissioner McGowan?
Can we just take a 5-minute bio break?
Yeah, of course. Let's return at 12:39. Back ECMC commissioners. We are back on our July 12th hearing. We have before us docket 2211000310. It is an enforcement matter. I have no idea who's presenting on this, so I will recognize whoever shows up first. Ms. Herman?
Yes, that would be Mackenzie Herman, representing ECMC staff, enforcement staff. Thank you.
Great, and I see Mr. Schultz is with us as well. Take it away.
Excellent. Okay. Can you all see my screen?
We can.
Perfect. All right, good afternoon, commissioners. I'm Mackenzie Herman. I'm an Assistant Attorney General Fellow and I represent ECMC staff. In this hearing, ECMC enforcement staff is requesting that the commission enter order finding violation 891 against the operator DJ Simmons Incorporated, which I will refer to as DJ Simmons. So DJ Simmons is the operator of 4 locations in Dolores and La Plata counties. Of relevance here, staff records indicate that all 4 wells associated with these 4 locations have been plugged and abandoned. And on May 11th, 2022, staff audited DJ Simmons and found that it had not submitted a Form 4 sundry notice for any of the 4 locations, and that is a violation of Rule 1004C4. And we won't dive too deeply into the federal bankruptcy matter, but we wanted to highlight that DJ Simmons filed for Chapter 11 bankruptcy in 2016 in the District of Colorado. And as part of those bankruptcy proceedings, a number of wells were transferred to Four Corners Energy, LLC. That Chapter 11 bankruptcy was converted into Chapter 7 in 2017, and the Chapter 7 bankruptcy closed in 2011. A notice of alleged violation was issued on September 14th, 2022. The NOAV included 4 violations of Rule 1004C4, one for each of the 4 locations, and staff issued a notice and application for hearing on December 13th, 2022. This notice was promptly published in 3 publications. Turning to the Rule 1004C4 violations, this rule requires an operator to submit a Form 4 sundry notice after plugging and abandoning any well. This Form 4 must describe 3 things. 1, the final reclamation procedures. 2, any applicable changes in the landowner's designated final land use. And 3, any mitigation measures associated with the final reclamation performed by the operator. And a Form 4 must be completed and submitted in order for final reclamation to be considered complete. And as you can see, DJ Simmons has 6 active cash bonds totaling $155,000. And DJ Simmons is the financial insurance provider for all. Enforcement staff requests the commission to order DJ Simmons to 1, be found in violation of Rule 1004C4, and 2, pay a $600,043,880 penalty within 35 days after the order is mailed by the commission. Enforcement staff request that the commission order include requirements that if DJ Simmons does not return to compliance or pay the penalty imposed within 35 days, that the director shall revoke DJ Simmons' authorization to conduct oil and gas operations in Colorado and foreclose on the $155,000 in financial assurances. And finally, additionally, for the enforcement staff, we request that the commission order include provisions that allow for the director to, 1, declare DJ Simmons wells orphaned, 2, investigate, prevent, monitor, or mitigate adverse environmental impacts at the wells formerly operated by DJ Simmons, and 3, claim all equipment and saleable product related to DJ Simmons oil and gas operations. That being said, are there any questions from the commission?
Great, thanks for the presentation. Commissioners, questions for our staff? If we want to stop the slide share, that'll give us a little more room. There we go. Well, it looks like you did a phenomenal job presenting to us because there are no questions from the panel. With that, what form of motion are we looking for here? Mr. Davenport.
It would be a motion to approve the order as presented.
Looking for said motion.
So moved.
So moved. Second.
Motion and a second to approve the order as presented. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you. Appreciate the presentation, and thank you for bearing with us this afternoon. I believe, commissioners, that brings us to the need to have a motion to adjourn. We've accomplished all of our business.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned. Thank you so much to everybody for the first meeting of the Colorado Energy and Carbon Management Commission. We look to have many more. Take care.